Just keep your, okay, I will make you. Keep your seat, relax. Try to work on this way, actually, to be very nice. The result will make both the parties happy. It's Adit's contention that it is damaged beyond repair, it cannot be remanded, or the demand cannot be again raised. That I am not accepting. Because that will be amounting to expensive. As I have said, discussed many times, I am remanding the matter to the station 21.5. 21.5 will not buy a company. Binding authority, you will hear everyone. Whoever has to say. But they have to appeal. Because no further, they will appeal on the particular date. Only because since this issue has been raised in this out of 10, 6 or 5. 6 years. So rest more, I have directed it is their choice. If 6 you can appeal and participate, say their question. But they suggested they will file for the documents, relevant documents. Whichever is not available, you tell the reasons and intimate them. It is not available, they will not give us. It will not detain the proceeding. Since Mr. Balit's expressed personal difficulty or other outcomes of the process, for that the appearance date is I don't know if Mr. Balit is the hands also not there. So and also liberty granted, if they agree, they will challenge the legal and authorities will have the liberty to go ahead. So this issue of course, I have not accepted the contention that notice on that particular HPJ is sufficient about the part of the practice. But yes, this authorities have the opportunity to. Okay. Agreed on. Yes.
डायरेक्शन स्पेसिफिक डायरेक्शन सेक्शन लगी लेफ्ट ओवर मैटर सुनंतु सर आपन को अकोमोडेट करे पे खाली मु 50 55 लिस्ट कली फॉर दैट रीजन नो और खाली इंट्री ऑर्डर टा टिके एक्सटेंशन हे गेला 18 6 को से तळ कोट डेट टा अछि कोर्ट टा खोली पाइछ आपन मेमो दियंतु मेमो देबे स्पेशल नोटिस हो नले हे परिवन चाहाटा हे परिवन लॉ रे हो परिवन very interesting. Before rising, if your lordship will please then matter. Before rising, sir, I am for the entire day. But lordship today the day is packed. Yes, I know. You have to bid farewell. There are so many. You have invited us at 1. Registry invited at 1:30. We'll meet at 2:45. The entire day is packed. अपन देखे से पढ़ना है. मेमोडा लिखी देले कि ठीक है. और डेट टा कोई दिन नहीं तला लिखोंतु. The reason being the file needs to be traced. धरंतु सेडा लिस्ट रे थिबो, रजिस्ट्री रे थिबो, कि आंक पाखरे थिबो. दे लास्ट ऑर्डर टा दी दे. They are also managing. से जो हमें रिमोट लोकेशन आमे बसछु से माने आछुंती फाइल पर कलेक्ट करछुंती. Their work is not that simple. Yes. 4 to 8
item 5
sir.
Therefore after vacation on behalf of Mr. Pradhan Garcha.
Your name sir?
Devashish Sahu.
Item 5 लिखंतु Mr. Devashish Sahu on behalf of Sanjay Kumar Pradhan for the one more paragraph, Mr. Lenka. That paragraph in the other that you will apprise, the parties shall apprise the learned whoever authority, whoever is taken up regarding any Supreme Court order concerning this person. That paragraph is there, common to both. Because that is appellate, that is of course appellate. Here it is the original.
Item 4.
Just once. Copy couple फिर सस्ता पूछिए समय पर. हाँ, yes. The matter was presented before this court on 28/2/2023. After for the last more than 3 years, for the last 3 years and 3 months, the matter has not been listed. To date is listed for fresh admission, and adjournment is sought for on behalf of the learned counsel for the petitioner at the beginning of the day's proceedings seeking adjournment. Accordingly, the matter shall be listed for fresh admission in the week commencing 27/2026. Yes, please.
Item 4.
4, Mr. Mahapatra.
I prefer
अच्छा, मुझे 4 देखूँ ना 5 देखूँ. Yes.
after vacation, your lordship.
Yeah, I was about to dictate. Yeah, I dispensed on the delay continuation. Mr. Mahendra Kumar Mahapatra for the petitioner.
That I may be
Same, the petition was presented on 3/2/2023 and is listed for fresh admission. After 3 years and 3 months, the matter is mentioned by the learned counsel for the petitioner at the beginning of the day's proceeding seeking adjournment. To grant further opportunity to the petitioner, the matter shall be listed for fresh admission in the week commencing. Odisha. आईएटा कहीं पेंडिंग रख लो, किस तो नहीं. Anyway, ठीक अच्छी.
Phase 2,
Item note 10, my lord. After vacation.
आपको ना सर
Sanjay Kumar Parde.
संजय कुमार पढ़. The matter is listed for fresh admission and is mentioned by the learned counsel for the petitioner at the beginning of the day's proceeding seeking adjournment. To grant further opportunity to the petitioner, but the matter shall be listed in the for fresh admission in the week commencing 27/7/2026.
My lord, item 20.
20. And Soumya Kumar Mishra for the
My prayer is before rising, your lordship, may I take up
ये कॉपी सर्व करो
for the challenge.
और इन्फॉर्म करो तो मिस्टर रेंग
Again. They such copy, they such.
कहीं तो उनको फोन करो.
Again.
Anyone present, since there is a packed schedule today, so anyone present who want to, if both sides agree, then matter can be taken.
Inform for.
Yes. तापरे 21 ରୁ 24.
My lord, item number 27.
नहीं 24, 1 second, 24 गल.
Phase 4,
25 ରୁ 27. 27 कौन क्वेश्चन सर?
Permitted to withdraw. Opposite party is present.
You are Mr. Mihir Kumar Das.
Again. मैं
अजय नायक सर आपण. Okay. Memo on instruction file करछन. IA file है. That is the notice. Okay. That order will be passed. Mention है ना. Yes, 28/2/33.
well, item 33.
Yes.
There are 4 matters. I may be permitted to withdraw with liberty to file better application.
এটা ফ্রেশ না ইয়ে
Fresh.
মানে কিছু নোটিস
না,
ହେଇନି
notice
କିଛି ଟେକ୍ ହେଇନି
না।
ହେଇପାରିବ
ହଁ।
উইথড্র ହେଇପାରିବ.
Withdraw with liberty to file better application.
ଓକେ ଓକେ. ବଟ୍ ପ୍ରୋବ୍ଲେମ ଆପଣ କଣ୍ଟେମ୍ପଟରେ 1 year ଲିମିଟେସନ ଅଛି.
ନାଇଁ ଅଛି ଏଠି।
ସୋ ରିଫାଇଲିଂ ୱିଲ୍ ନଟ୍ ଷ୍ଟପ୍ ଦ ଲିମିଟେସନ.
ତଥାପି ଥାଉ liberty.
ଆପଣ ସେଇଟା ଟିକେ ଭାବିକି ୱିଥଡ୍ର କରନ୍ତୁ.
ନାଇଁ ମୁଁ ଖାଲି ଗୋଟେ
I please appreciate this. I am not speaking. I am just assisting you. My thought process I am just sharing with you.
Right.
When there is a contempt limitation ଅଛି and limitation is strict.
ତାର ଟିକେ ଭୁଲ ରହିଛି ତ ସେଥିପାଇଁ।
Whatever. ଆପଣ ଥରେ withdraw କଲେ ଆଉ limitation ଟା will continue running. ଠିକ ଅଛି। Withdraw ନେଇଯିବ। That order will be passed.
with liberty to file better
Yes, yes, with liberty.
liberty
ଆପଣ ଲେଖିନାହାନ୍ତି କି ସେଇଟା?
ହଁ ଲେଖିଛି ମେମୋର
ମୁଁ
ଲେଖିଛି
ଦେଖିବି ସେଟା।
ମେମୋର ଲେଖିଛି
Usually I quote the memo.
Right.
Yes.
Pardon, my lord.
Please.
Item 31, my lord.
31.
Come after vacation.
Other side, Raspi Ranjan,
But they have not appeared. Notice is gone or not. 31.
Sasmita Das. ତେବେ ଆପଣଙ୍କୁ ଇଏ appearance ହେଇପାରିବନି। ସସ୍ମିତା ଦାସ ଚିରି ଦେଇଥିବେ। ବନଜ ରାଉତ versus ରଶ୍ମି ରଞ୍ଜନ ତାକୁ ରିସିଭ୍ କରିବେନି ସସ୍ମିତା।
My lord, what has happened
There
in
is
this
problem.
matter? There's a judicial order. The notice where the
Crowded,
notice was issued.
The
matter was adjourned.
the address's place is crowded now.
Yes,
କେବେ ଆସିବ?
but the matter is actually adjourned to 29th week commencing 29th June, as per the judicial order.
ମାନେ 29 by High Court ନା ସେଠି?
By High Court, man.
ନାଇଁ ଏଇଟା
This matter.
ଆପଣ ଏଟା କେବେକୁ ଆସିବ କହୁଛନ୍ତି?
29 week commencing 29 as
29 29 କରିଦେବେ। ହେଲା simple adjournment ତ?
month.
Yes.
DPU.
Yes.
My lord, pardon. I mean VC, my lord.
Just 1 second. Just
My lord. My lord.
32,
34.
34.
I prefer noon after vacation.
Before is rising, you're not so kindly hard. That matter.
କୋଉଟା?
Same it.
ତ ଆପଣ ଯୋଉ ଇମୋସନାଲ ଆରେ ସେଟା ତ ହବା କଥା ନୁହଁ ଆପଣ ଆଉ କାହାକୁ ଆପଣ ଇମୋସନାଲ ହେଇଯାଇଛନ୍ତି
No.
ଆଜି ତ ଆସ ଦ ମାହୋଲ ଇଜ ଇମୋସନାଲ somebody is partying and retiring bar is emotional so you will be more emotional so yesterday at around 9:35 president secretary vice president they are moving around when they have things have become so formal of course seniors they have to but still they are moving around and searching for us I was told that I was not found. So
actually, ସେ ଗୋଟେ ପୁରା ଜିପିର ଗୋଟେ ଗ୍ରାମ ପଞ୍ଚାୟତ ଲୋକ 5 କିଲୋମିଟର ମୁଭମେଣ୍ଟ କରୁଛନ୍ତି ଆଣିବା ପାଇଁ ତ ଆଜିକାଲି ସାର୍
ଏଇଟା ଆପଣଙ୍କୁ ମୁଁ ଆସିଷ୍ଟ କରିଥିଲି ମୁଁ କଣ କହିଥିଲି
ସାର୍ ଆକ୍ଚୁଆଲି କଣ ହେଇଛି ଯୋଉ ବୟସ
ନାଇଁ ଆପଣ ମୋ କଥା ଶୁଣିଲେନି ମୁଁ ଏଇଟା କହିଥିଲି ଆକ୍ଚୁଆଲି 5 କିଲୋମିଟରଟା ଗୋଟେ ସେପାରେଟ କଜ ଅଫ ଆକ୍ସନ ହେଇପାରିବ ଆପଣ you did not get the hint ଯୋଉ ଲୋକ 5 କିଲୋମିଟର ଯାଉଛି ରାସନ ପାଇଁ he is an independent person he has a separate cause of action but problem is that Mr. Lenka and Madam Rana will feel bad about it that I am giving a hint so ସେଇଟା ଆପଣ ଦେଖିବା ଖାଉ adjournment में ରାଜି ନୁହନ୍ତି but ଏଟା ପଡିବନି ଚାନ୍ସ today schedule is too hectic ଆପଣ ବଡ଼ rather fixed date ନିଅନ୍ତୁ ଆଉ ମୁଁ ଯୋଉଟା କହିଥିଲି ଆପଣଙ୍କୁ inaction on part of the authority is a separate cause of action
ଗୋଟେ ପିଟିସନ ବି
ଆପଣ ଯଦି beneficiary of you are a alertee
ଆଜ୍ଞା
you are a PDS distributor
ଆଜ୍ଞା
but consumer is a different entity
ଆଜ୍ଞା
so that is different you did not get that hint ଆପଣ emotional ହେଲେ hint ପାଇବେନି ସେଟା yes କେବେ କୁହନ୍ତୁ ସେ decide କରିବେ date ଟା
ସାର୍ ରିଓପନିଂ
29/6
ଫାଷ୍ଟ
ନା ଫାଷ୍ଟ ଠିକ ଅଛି actually 29/6 ଟା ଫାଷ୍ଟ next week ଟା ହଉଛି 6/7
ନା ନା ମାନେ 22 ୱିକ୍
22 ରେ ରଖନ୍ତୁନି 29/6 ରେ ରଖନ୍ତୁ so that at least if any kind of listing issue ରହିବନି जब 34 टा 29/6 रे रखନ୍ତୁ yes Mr. Mahanti
Pardon, item 39 do not reach.
30
Item 13, I prefer.
नहीं ଆଉ ଯୋଡେ ଗୁଡିକି मेंशन करथिले फर्स्ट पेज ओ सेठी আছে त्रिपाठी त्रिपाठी को मैटर
My lord, item number 6. Item number 6, my lord. The छुट्टी purpose. My lord, item number 6, my lord.
प्लीज जस्ट 1 सेकंड ଆପଣଙ୍କର ଲ୍ୟାପଟପ୍ କୋଡା ଗଲା ମୋବାଇଲ ଫୋन ପଳେଇ ଆସିଲେ
Laptop ମୋର ନାହିଁ, my lord.
ଆଚ୍ଛା ପ୍ରାକ୍ଟିସ ଯୋଉ କରୁଛନ୍ତି ତା କରୁଛନ୍ତି କଣ
My lord,
ସ୍ଟୁଡେଣ୍ଟ ମାନେ ଲ୍ୟାପଟପ୍ ନିହାତି ଦରକାର ନା ଲ୍ୟାପଟପ୍ ରେ ସ୍ଟୁଡେଣ୍ଟ ହେଇପାରିବେନି
laptop my lord ଦେଖା ହଉନି ସେ ଛୋଟ ଛୋଟ କି ଗୁଡା ତ
ଆପଣ ତ ଚଷମା ଲଗାଉନାହାନ୍ତି ଦେଖାଯିବ 6 ହାଇବ୍ରିଡ ମୋଡ ଲେଖିବେ Domake Tripathi for the petitioner. The petition was presented before this court on 17/3/23 and thereafter is listed today after 3 years and 2 months. Stuff. The Lord Counsel for the petitioner listed today for fresh admission. The Lord Counsel for the petitioner seeks adjournment at the beginning of the day's proceeding. Seeking adjournment, accordingly, the matter shall be listed for fresh admission in the week commencing on 30/6/2024 to grant further opportunity to the petitioner.
Deeply obliged, madam.
Yes, please. Mr. Mohanty?
Item 13, madam.
Mr. Maheshwar Mohanty for the petitioner. The matter is listed for fresh admission and mentioned by the Lord Counsel for the petitioner seeking adjournment at the beginning of the day's proceeding. Stop. To grant further opportunity to the petitioner, the matter shall be listed in the week commencing on fresh job.
No,
Fresh रखंतु fresh उड़ागा अपन भी आगुआ रखंतु
29.
Yes. To be mentioned.
Please, your lordship.
To be mentioned item 1.
I'll that. और इसको कोई भी रास्ता लगी था What is the order? Yes,
In this case, your lordship,
yes, Mr. Uttam Kumar Mohanty for the petitioner.
I appear for the opposite party.
Along with Siddhant Solanki for the opposite party. Yes.
Sir, your lordship had sent it for mediation. Mediation is successful.
Yes.
The terms and conditions is there in the mediation report itself.
Yes.
So we agree for that. Your lordship has to pass a formal order. Now my learned friend requested me if the matter proceeding could be held at Cuttack because it was filed at Bhubaneswar by my clients and he wanted a transfer to Keonjhar.
Yes.
So
Katak ho. Both of you
ଆପଣ
can
କୁହନ୍ତୁ ମୋର କହିବା କଥା ହେଲା ଆପଣ କୁହନ୍ତୁ parties cannot confer jurisdiction that let court say and I may be excused with that, your lordship,
Yes, please. Please, you carry on, please.
and have a good holidays.
And to you also. Have a nice holiday. The efforts of the Learned Counsel for the parties have yielded result. The mediation pursuant to the order passed by this court dated 14/8/2025 has ended up in the parties agreeing to an amicable settlement acceptable to both. The report of the mediation is reproduced here. Ekuru in the above circumstances, mediation becomes optional. Scan करके for paper. Scan it and the opposite party husband in the marriage had initiated the proceeding at has filed CP number 50 of 2025 before the Learned Judge, Family Court, Bhubaneswar, under section 13 of the Hindu Marriage Act, seeking divorce. No, so under section 27 of the Special Marriage Act, 1954, seeking divorce. ଆପଣ କଣ ଫାଇଲ କରିଛନ୍ତି ଆପଣଙ୍କର କେଉଁଝରରେ ଫାଇଲ କରିଛନ୍ତି
He had filed a petition for transfer.
only
Only for.
the wife The petitioner before this court is the wife in the marriage.
A petitioner, yes, Your Lordship.
She is the respondent before the Lord Judge Family Court in the CP 50 of 2025. She has prayed for transfer of the CP from the Lord Judge Family Court Bhubaneswar to Kendujar,
Keonjhar.
to the Lord Judge Family Court Keonjhar. Para. It is a matter of satisfaction that the parties have agreed for settlement and filed their application under 13B by invoking that file application invoking section 13B of the Marriage Act for grant of decree of divorce on mutual consent. In considered view of this court, as the parties have been able to appear at Cuttack before this court, as well as the mediation center at Cuttack, as well as the mediation center, court annexed mediation center at Cuttack. In the interest of justice, the application under section 13B shall be filed jointly by the parties before the Lord Judge Family Court, Cuttack. The CP number 50 of 2025 shall be transferred from the Lord Judge Court of the Lord Judge Family Court, Bhubaneswar, to the Lord Judge Family Court, Cuttack. The Lord Judge Family Court, Cuttack, upon transfer, shall deal with the section 13 application after the decree, the judgment and decree is passed in the application that would be filed under section 13B of the Hindu Marriage Act. Till disposal of the said CP to be filed, the other application under section 20, that is CP 50 of 2025 shall not be dealt with. Stop. It is further directed that the Lord Judge Family Court, Cuttack, shall not detain itself for the period to proceed with the 13B application as prescribed under 13B2. And then point
13B2.
13B2, not 13B2 in view of the judgment of the Honorable Apex Court in so and so versus Harvin Kaur. ଆପଣ ସାଇଟେସନ ଗୋଟେ ପଚର ଲେଖିଦଉଛୁ ଆବାସ ବିକାଶ ଏବଂ କନଷ୍ଟିଟ୍ୟୁସନ ବେଞ୍ଚକୁ ଆପଣ 2 ଜଜ୍ ବେଞ୍ଚ କରିଦେଲେ ସୁପ୍ରିମକୋର୍ଟ ବି ଆପଣ ଏମିତି କରୁଛନ୍ତି ସୁପ୍ରିମକୋର୍ଟ ଆପଣଙ୍କ କଥା ପଚାରିବେନି ମୋ କଥା ପଚାରିବେ ଅମରଦୀପ ସିଂ versus Harvin Kaur ଏଇଟା ସବୁ ମନେ ରଖିବ କେମିତି everything cannot be remembered. Amardeep Singh versus Harvin Kaur. That period is waived because I understand that this court cannot.
The Lordship may direct the parties to appear on a date.
Yes, the parties shall appear before the Lord Judge Family Court, Cuttack. Date fix karantu.
24th June.
24 June 2026. The registry of this court shall forward copy of the today's order to the Lord Judge Family Court, Bhubaneswar, as well as the Lord Judge Family Court, Cuttack, to do the needful.
Obliged.
Yes.
The
petition is disposed of.
Obliged.
Before party, all the interim orders stand vacated in view of the order passed today. Before parting with the case, this court puts on record appreciation of both the Lord Counsel for the appearing parties for making it possible for the parties to arrive at a mediated settlement acceptable to both. So,
Obliged.
Mr. Tripathi, someone was mentioning a matter. Okay, you have instruction. So I will take it up. I just informed you because you are not there. Yes. Next.
You mentioned item 2.
Madam, this is the affidavit I am
Yes.
filing.
Okay, okay.
And the person concerned is also present in the court. Paragraph 4 may kindly be said that's his submission.
ଗୋଟେ 7 paragraph ଲେଖିଛନ୍ତି ତାପରେ ଲେଖିବେ ଗଭର୍ଣ୍ଣର ସାର୍ ଲେଖିଛନ୍ତି ବୁଝିଲେ ଲେଖିବେ the petitioner the matter is urgent ତାପରେ କାଲି ଅର୍ଡର ଆପଣ ଲେଖି ଦିଅନ୍ତୁ 20/5/26 ଅର୍ଡର ଆଉଥରେ ଲେଖନ୍ତୁ it is submitted by the Learned Counsel for the 20/5 submitted by the ଲେଖିବେ hybrid mode তারপরে the matter is taken up in the virtual court is submitted by Mr. Mohanty, Mr. Das, Jaminikanta Das for the petitioner, Mr. Das Learned Counsel for the petitioner, that the petitioner shall file affidavit regarding deposit of amount in order to secure the decree. The 3 lakh reduce karihabani. He may be a pauper.
Correct.
Sir, we are not on an expedition to find out how he will pay.
Correct.
For execution is the execution re kon khoja huye.
No, that's not my submission.
No,
His-
property and A. This has to be rejected.
Yes.
Shall file affidavit. Hala.
Kindly mention that he is present in the court. So to rule out any further eventuality.
Hala. According to the matter shall be listed tomorrow.
Tomorrow?
ସେ କେତେ ଟଙ୍କା ଦେବେ କହୁଛନ୍ତି ଆରେ 20/6 ରେ ଆଜି 21 ଆପଣଙ୍କର
25/6 ରୁ ଅନର୍ସ ଅଛି ସେ କହୁଛନ୍ତି 3ଟା ଇନଷ୍ଟଲମେଣ୍ଟ
ଇନଷ୍ଟଲମେଣ୍ଟ ହେଇପାରିବ ଜେଲରେ ରହିଲା ପରେ ମୁଁ ଏଠି ଆଜ୍ଞା ତାଙ୍କର ଆସିଷ୍ଟାଣ୍ଟ ନୁହଁ ଆଜି ଯୋଉଠି ଏଠି ଛିଡା ହେଲେ ମୁଁ ତାଙ୍କୁ ଆସିଷ୍ଟ କରିବି ହାଉ ଟୁ ଭାଉଲେଟ୍ କୋର୍ଟ ଅର୍ଡର ଦ୍ୟାଟ୍ ଇଜ ଏ ଭେରି ରଙ୍ଗ ଇମ୍ପ୍ରେସନ ତାର ହାତ କାହିଁ ହାତ ଯୋଡ଼ିଛନ୍ତି ହାତ ଯୋଉ ଯୋଡ଼ିବା କଥା ଯୋଡ଼ିବେ ଆଜ୍ଞା ଉପର ବାଲା ଅଛନ୍ତି ନିମିତ୍ତ ମାତ୍ର ଏଇଟା 20/5 ରେ ଆସିଥିଲା କି ଆଜି 22 ହଁ 20 ରେ ଆସିଥିଲା ଆଚ୍ଛା So it is to ମାନେ 20 ରେ ବୋଧେ ଥିଲା ଫିଜିକାଲ ନା 20 ରେ ଫିଜିକାଲ ଥିଲା
ଆମେ ଆଫିଡେଭିଟ୍ ଦେବା ପାଇଁ କାଲି କହିଥିଲୁ
କାଲି ରହିଥିଲା
ଆଜ୍ଞା
ଆଚ୍ଛା
ସେଇଟା
ତ ଠିକ ଅଛି 20 ରେ ଗୋଟେ ଅର୍ଡର ହବ 21 ରେ ଗୋଟେ ଅର୍ଡର 22 ରେ ଗୋଟେ ଆଟଲିଷ୍ଟ ଆପଣଙ୍କର ୟୁ ହାଭ୍ ଗଟ୍ ଏ ଗୁଡ୍ ଆପଣଙ୍କ ଓକିଲ ଭଲ ଲୋକ ସେ ଚେଷ୍ଟା କରି 3 ଦିନ ହେଲା ମ୍ୟାଟରଟା ଗଢଉଛନ୍ତି ଆଉ ଜଜ୍ ଭଲ ଖରାପ ଅଲଗା କଥା କିନ୍ତୁ ସକ୍ସେସଫୁଲି ସେ ଗଢେଇଛନ୍ତି 3 ଦିନ ହେଲା ଆପଣଙ୍କର this I am rejecting ହେଲା rejected and this order will be sent to the court ଆପଣ କେତେ ଟଙ୍କା ଦେବା ପାଇଁ ସେ କହୁଛନ୍ତି 3 ଲକ୍ଷ ଟଙ୍କା ଜାଗାରେ ଦେଖନ୍ତୁ
କେତେ
2 ଲକ୍ଷ
ଡିପୋଜିଟ୍ କରିବେ କାଲି ଇନଷ୍ଟଲମେଣ୍ଟ ହେଇପାରିବନି
25/6
ଆପଣ ଆଜ୍ଞା ଆପଣଙ୍କ ଟୋଟାଲ ଡ୍ୟୁ 16 ଲକ୍ଷ ନା କେତେ
11 ଲକ୍ଷ
11 ଲକ୍ଷରୁ ଆପଣ ଖୁସିରେ 2 ଲକ୍ଷ ଟଙ୍କା ଦେବେ ଥରେ ଏନବିଡବ୍ଲ୍ୟୁ ହାଇକୋର୍ଟ ଡାଇରେକ୍ସନ ଦେଲେ ବୋଲି ସେଟା 2 ଲକ୍ଷ ଦେଇଥିଲେ 11 ଲକ୍ଷରେ ମାନେ ଟିଲ୍ ଡେଟ୍ 11 ଲକ୍ଷ ଟିଲ୍ ଡେଟ୍ ତାପରେ ଇନଷ୍ଟଲମେଣ୍ଟ ନେବେ ଇନଷ୍ଟଲମେଣ୍ଟ ଭିତରେ ହେଇପାରିବନି ଆଜ୍ଞା ଯିଏ 1 ଲକ୍ଷ ଟଙ୍କା ସେ 50,000 ବି ଇନଷ୍ଟଲମେଣ୍ଟ ମାଗୁନାହାନ୍ତି ଯାହା କରିବେ ଛାଡ଼ି ଦିଅନ୍ତୁ ସେ ହେବେନି he does not, he will not give to any advice ଆଜି ହେଉଛି 22 ତ 20-21 ଅର୍ଡର ଲେଖା ହବ 22 ଅର୍ଡର ଲେଖା ହବ 22 ଲେଖନ୍ତୁ pursuant to the orders passed on 20/5/2026 and 21/5/2026 the Learned Counsel for the petitioner submits that the petitioner is present in court. He is identified by the Learned Counsel. Affidavit dated 22/5/2026. Affidavit of 22/5/2026 is filed in court by the Learned Counsel for the petitioner, wherein The petitioner has stated regarding his financial condition as on date. And seeks waiver of payment of the amount of rupees 11 lakhs due. Due to be paid as directed by the Lord Judge Family Court, Punjab. Which comes to around rupees 11 lakhs, being payable from 11/7/2018. The earlier after NBW was issued in the execution case, he approached this court
No, the
in
other end,
CRLMC number 5296 of 2025.
I was the opposite party there.
Only no. Party na likhi please. Eta purbo sentence. Oh, yeah. Issuance of NBW in the execution case against the petitioner being the judgment debtor. He approached this court in CRLMC number 5296 of 2025. This court by disposing of the CRLMC had directed for payment of rupees 2 lakhs, which he complied with. After that, again he failed to pay any amount, and his attitude is evident from the non-compliance of the judgment dated 26/4/2021. Judgment and decree 26/4/2021, which he remains in default for the last 5 years. The petitioner has been shown sufficient indulgence, being persuaded by the learned counsel for the petitioner, as would be evident from the order stated 1/5/2026, 20/5/2026, 21/5/2026, and 22/5/2026. And 21/5/2026. The prayer for granting installment and to allow deposit rupees 3 lakhs within 1 month is rejected. Copy of this order shall be forwarded to the learned judge family court. So and so, to be kept in the execution proceeding arising out of the judgment dated 26/4/2021, passed in CRP number 198 of 2018. The learned court shall proceed in accordance with law. Roughly. ଆପଣ ଗୋଟେ 20 ରେ ଗୋଟେ affidavit ଫାଇଲ କରିଥିଲେ ନାମ ହେଟା କାଲି 20 ରେ ଗୋଟେ affidavit ଫାଇଲ କରିଥିଲେ
ଆମେ ଯୋଉଟା ଡିପୋଜିଟ୍ କରିଥିଲୁ
ଆଜ୍ଞା
ସେଇଟା
ଆପଣ 3 lakhs କହିଥିଲେ ନା
ଆଜ୍ଞା
3 lakhs ସେଟା 3 lakhs ରହିବ कोड़े तारीख रे आपण ऑर्डर अछि 3 पैराग्राफ 4 पैराग्राफ लिखंतु आज प्रेड फॉर by the learned counsel for the petitioner the matter shall be listed to be mentioned on what? Tomorrow, that is 21/5/2026. ପୁଣି 20 ଅର୍ଡରଟା ହେଇଗଲା ହେଲା ତାପରେ ଲେଖିବେ 21 hybrid mode, the matter is taken up in VC. The hard ordered counsel for the petitioner, he refers to the order dated 20/5/2026 and submits that the petitioner shall appear and file affidavit if given some time. Stop. The matter was passed over to be taken up later. However, due to paucity of time, the matter is adjourned to be taken up tomorrow, that is 22/5/2026, marked as to be mentioned. ତାପରେ ଆଜିର ଅର୍ଡର ଏଇଟା ଆପଣ ଆଜି ଲଗେଇବେ yes.
To be mentioned item 3.
Still, Mr. Das, if you have marked, I don't know, at times, I have recorded that 3 lakhs.
Yes.
I was somewhat reluctant, but still I have, since I told 3 lakhs, I have recorded so that he gets a chance because he is a kind of a impossible person.
Yes.
Yes.
You will see in procedure receipt. I'm having this affidavit and undertaking.
Again, I don't know. Maybe go to the copy de copy de nahi.
No. Even I have not received a copy of the writ petition also.
Copy de babu de. যেটা উভয় পক্ষে জিতুছেন সেটা সমস্ত বাটিকে নেওয়া
Yesterday, he has a fine power.
ଯାହା ବି ହଉ ଆପଣ ଆଜ୍ଞା ସେ ହିୟରିଂ ହେଲା ଆପଣଙ୍କ ପ୍ରେଜେନ୍ସରେ ଆପଣ କହୁଛନ୍ତି ଷ୍ଟଡି ହିଜ ଫାଇଲ୍ ପାୱାର ଗୋଟେ କାର୍ଟୁନ ଆସୁଥିଲା ଆଇ ଗଟ୍ ପାୱାର ଆପଣ ସେମିତିଆ କହିଲେ ଆପଣଙ୍କର ପାଇଲେ କି ନହେଲେ ଏଇଟା ପଢୁନାହାନ୍ତି କପି ଦେଲେ
Sir.
ଆପଣ ପାଖରେ କପି ନାହିଁ ହେଲା ପାସୱାର୍ଡ ଜେରକ୍ସ କରି କାଢ ଅଛି ନା ନାହିଁ ସାର୍ so that we can proceed କରିଦିଅ କୋଉଟା ସେଇଟା କରିବ ସେଇଟା କଣ ସେଇଟା ଅରିଜିନାଲ ଫଟୋ କପି ସେମ୍ ସତରେ ଏଇଟା କରିବା ଠିକ ଅଛି ପାସୱାର୍ଡ ନେକ୍ସଟ
Item 7.
yes
Affidavit I'm filing. He'll
Yeah.
he will deposit 3 lakhs within 3 weeks.
85 ରେ ଏତେ କଣ ଅର୍ଡର ହେଇଛି କି
ହଁ
7 ରେ ଅର୍ଡର କଣ ହେଇଛି ଫାଇଲ
କାଲିକା
ଏଇଟା ଆପଣ ଦେବେ 7 ଆଇଟମ ଟା ଟିକେ ବାହାର କରନ୍ତୁ ଏଇଟା ପାସୱାର୍ଡ କପି ଟା ସେ ଆସିବେ କପି କରିକି ଆଣିବେ The hard-learned counsel for the petitioner. The petitioner, the learned counsel refers to the order dated 21/5/2026, which was passed after hearing the learned counsel at some length. Stop. He files IA on behalf of the IA. He files IA 290 of 2023. It a physical copy, Mr. Physical. Filed on 22/5/2026. Supported by affidavit dated 22/5/2026. नहीं कौन भूल भाल ହେଇଗଲା सर એટલે करेक्शन करो 5 ଜାନୁଆରୀ ହେଇଛି କୋड टाइप कला बेले सेटा को चेंज करना
সেটা চাই
ହେଲା सपोर्टेड बाय affidavit stop কোন কাউন্টরে মিস্টার মহান্তি আଜି ফাইল করছেন আইএটা
ଆଇଟା ଆଗରୁ ଆରପିଏଫଏମ ସାଙ୍ଗରେ ଫାଇଲ ଷ୍ଟେ ଆପ୍ଲିକେସନ ତାର ଦେହରେ ମୁଁ ଆଫିଡେଭିଟ ଦଉଛି ତମେ ଡିପୋଜିଟ କରିବ ଯୋଉଥିରେ ଷ୍ଟେ ଚାହିଁଛି ମୁଁ।
नहीं सॉरी आई एम लिटिल बिट कंफ्यूज ये जो आईए नंबर टा पड़िला एटा ऑलरेडी अछि
ଅଛି ଏବେ।
अच्छा he files an affidavit in the pending IA number 2902023
ଆଜ୍ଞା
affidavit जो लिखले नी he files affidavit 22 में ଆପଣ affidavit ଟା 22 में ना अन्य ତାକୁ କାଟୁଛନ୍ତି ଯୋଉ ତାକୁ ଗୋଟେ ଦସ୍ତଖତ ମାର
ମୁଁ କରୁଛି।
କୁହନ୍ତୁ affidavit in the pending IA number एते which is taken on record affidavit dated 22/5 in the pending IA
ଲାଷ୍ଟ ଲାଇନ ଅବଶ୍ୟ ଡେଟଟା ଅଛି କରେକ୍ଟ ଡେଟ୍ ଇଜ ଦେयर ଲାଷ୍ଟ ଲାଇନ
ए लास्ट ରୁ ବି ତ ମୁଁ ଜାଣିନି
ନାଇଁ
otherwise I would not have dictated ଆପଣ ଲାଷ୍ଟ 22 ରେ ଏକ୍ସଚେଞ୍ଜ କରି ମୁଁ ଡିକ୍ଟେସନ ଦେଲି ସେଥିପାଇଁ ସେ ବି କନଫ୍ୟୁଜ ହେଇଗଲେ
ଆଜ୍ଞା ଆଜ୍ଞା
22/5 ହେଲା the affidavit states thus para 2 कर देवे एंट्री करते हैं तो he files an undertaking supported by affidavit in the pending IA that language will be better para it is submitted by the learned counsel for the petitioner that observation made by this court by at paragraph 2 of the order dated 21/2026 is satisfied and he seeks indulgence for issuance of notice to the opposite party para issue notice to the opposite party along with this today's order and order dated 21/5/2026 by speed post with registration and proof of delivery करेंट किसी ड्यू नहीं
ନା ନାହିଁ କାରଣ ଆରପିଏଫଏମ ଟା ଯୋଉ ଡିଭୋର୍ସ ଅର୍ଡରଟା ହେଲା
ठीक है देखिए आसन
ଡ୍ୟୁ ନାହିଁ ଏଭରିଥିଙ୍ଗ ଇଜ
हाँ along with so and so order requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within 3 or 5
5 working
within 5 working days returnable date be fixed to 1/7/2026 the matter shall be listed in the week commencing 6/7/2026 para आइए 290/2023 issue notice hard noted counsel for the petitioner he reiterates his submissions as noted above so issue notice as above accept one set of process fee as well as postal requisites as directed above the returnable date as well as the next date of listing shall be as directed above in the, as an interim measure it is directed that quota pending achi
ପେଣ୍ଡିଂ ଅଛି ଏକ୍ଜିକ୍ୟୁସନ କେସ୍ କରିକି
the pending execution case number dash shall be adjourned to a date beyond 13/7/2026 as would be convenient to the learned court in season of the matter upon a prayer being made for the said purpose.
ମୁଁ କିନ୍ତୁ ଷ୍ଟେ ଅପରେସନ ଚାହିଁଛି
ते ମୁଁ ଦଉ ନାହିଁ
କୋଉଥିରେ ସେଟା କହୁଛନ୍ତି ସାଲେରୀ ଆଟାଚ କରିଦେବୁ ସେଇଟା
salary attached to
ଏଇ ଯେ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଏମ୍ପ୍ଲୟ ତ ସେଇଥିପାଇଁ ମୁଁ ଚାହୁଁଛି
ନାଇଁ ଆପଣଙ୍କର ମାନେ କଣ ଆପଣଙ୍କୁ ନବାକୁ ଦଉନାହାନ୍ତି ପଇସା
ନାଇଁ ନାଇଁ ବର୍ତ୍ତମାନ ସେ ଗଭର୍ଣ୍ଣମେଣ୍ଟରେ ଦରମାଟା
ସେଟା ହଉ ହେଲେ ତାକୁ ଆଇ ୱିଲ୍ କ୍ଲାରିଫାଏ ଯଦି ଆଡଜର୍ନମେଣ୍ଟରେ ବି ସେ ଆଟାଚ କଲେ ସାଲେରୀ because it is a conditional order let them appear I'll take care of that already those kind of orders have passed in one matter Mr. Parija was arguing same thing happened so but he could not deposit
no coercive
so it was next blanket habani
no I cannot
blanket that is a purpose in because in view of execution cases have to be completed clear mandate of the Supreme Court so that is a difficulty
এটা 125 proceeding ରେ ସେଇଟାକୁ execute କରୁଛନ୍ତି ସେଥିପାଇଁ
ଆପଣ ଏଠି ଦିଅନ୍ତୁ ବଟ୍ ଆପଣ ସେଇ କୋର୍ଟରେ ଡିପୋଜିଟ୍ କରୁଛନ୍ତି ତ
ସେଇ କୋର୍ଟରେ
Yes, yes. So see, the court will be aware of that. Liberty to mention. ଆସୋକଟା ଦିଅନ୍ତୁ କପିଟା ମତେ
Azure item 3.
କପିଟା ଗୋଟେ ଦିଅନ୍ତୁ ଦେଇଦେବେ Yes, Mr. Patnaik.
Yes, my lord. Still,
ଆପଣ ପାରା 2-3 ଦେଖି ଦିଅନ୍ତୁ ଦେଖିବେ
yes, I have just now I have gone through the contents of the affidavit.
2-3-4 ଦେଖି ଦିଅନ୍ତୁ
4.
2-3-4 ଦେଖି ଦିଅନ୍ତୁ
Sir.
ପଢି ଦିଅନ୍ତୁ
4, para 4 is quite irrelevant. It has no relevance.
ନା ଆରେ ସାର୍ ମୁଁ କଣ ଅର୍ଡର ସେୟା କରିବି କି ଆପଣ କାହିଁ ଫେର କାଲି ଭଳିଆ ଆର୍ଗୁମେଣ୍ଟ କରିବା ଆରମ୍ଭ କରିଦେଲେ କାଲି ତ ଆପଣ ଗୋଟେ ମ୍ୟାଟର ନେଇଗଲେ ପୁରା ଅଧଘଣ୍ଟା ପଳେଇଲା ଜେଣ୍ଟଲମ୍ୟାନ friend of husband
ଭଦ୍ର ଲୋକ ସିଏ ଆମର ବାହାଘର
so
କରିଥିଲେ
Sir,
ଛାଡ଼ନ୍ତୁ ଆପଣଙ୍କର ଯୋଉ ପ୍ରୋବ୍ଲେମ ମୁଁ କାଲି ମନା କରିଥିଲି ମିଷ୍ଟର ପଟ୍ଟନାୟକକୁ ଆପଣ କାହାକୁ ୱିଟନେସ୍ କରିବେ ସେଟା ମୁଁ ଡିସାଇଡ୍ କରିବି ଆପଣ କୋଉଦିନ ଆପିୟର କରିବେ ସେଠିକି
may I pray one thing, my lord? Sir, under Article 227, your lordship has ample jurisdiction to direct the court below to dispose of the matter. But what happened?
decision ଟା ପଢି ଦିଅନ୍ତୁ ମୁଁ କାଲି କହିଥିଲି
What
Latest
happened?
decision, read Justice Arvind Kumar's decision, has extensively dealt with
Right.
227.
But what-
And basically, what you are saying, the court has, the Honorable Apex Court has strong exception. So I will not get carried away.
My lord,
Ample power in 227 is very circumscribed to, and it cannot be and more so, Mr. Patnaik, it is a trial.
I do agree with the contents of the.
At stage, even the Supreme Court has gone to the extent of limiting the power in the stage of appeal. Because 227 is not at all appeal. That's the point highlighted by the
In a
Apex Court.
CMP, my lord, your lordship is directing the court below. As the Honorable Court has the ample jurisdiction over the court below. Supervision.
Direction कौन
My lord, let me complete.
अरे डायरेक्शन सर पावर तो अछि मु कोन मना करछि
हाँ.
सीए कोचते साक्षी देबे आंकु आनिबे I cannot allow that prayer. I cannot allow that prayer.
1 minute. As the matter is the fag end of the trial, already all the witness has been examined. They slept 2 years. Thereafter, when the matter stands for the argument, they come forward and
That point is well taken, sir.
Sir,
That point is well taken. I will confirm the order. I have confirmed.
oblige.
These similar orders, I say that the order is just and proper. But however, as an exception, considering the prayer, I am granting that what you call exemption. More kind of it's not exemption. I am granting further time. That one.
1 month time may be given them to complete
ସେଇଟା
the trial.
ଆଗୋଟେ ପଢିବାକୁ ପଡିବ ଆପଣଙ୍କୁ ଟିକେ ପୁରୁଣା ଡିସିସନ ବଟ୍ କନଷ୍ଟିଟ୍ୟୁସନ ବେଞ୍ଚ ଆଲାହାବାଦ ବାର ଆସୋସିଏସନ 5 ଜଜ୍ ବେଞ୍ଚ ଆପଣଙ୍କର କାମ ହେଲା ୟୁ ହାଭ୍ ଟୁ ଏଡୁକେଟ୍ ମି ଆପଣ ଫାର୍ଷ୍ଟ ଡିସିସନ ଯୋଉଟା ପ୍ରଥମ ପ୍ରପୋଜିସନ କହିଲେ କମ୍ପ୍ଲିଟଲି ଏଗେନ୍ଷ୍ଟ ସୁପ୍ରିମ କୋର୍ଟ ପ୍ରୋନାଉନ୍ସମେଣ୍ଟ Honorable Justice Arvind Kumar. Elaborately he has dealt. At least he has devoted 6 paragraphs, 6 pages, 4-5 pages. Now this is completely in conflict with judgment of Constitution Bench in Allahabad Bar Association. Therefore, you see, Mr. Patnaik, Mr. Ratha, we should spend time in discussing legally nuanced discussions. Amara again largely is common sense. Upon jota kahuchandi that is appealing. You are not, what you are saying is incorrect, no.
That's
But
why
being not incorrect and whether I can issue that direction upon complete korantu, that's a that the Supreme Court has taken exception because it is a trial court. Trial court has to give time and do it. Because if I am not doing the trial, I cannot say that.
Right. Trial is already over. At the fag end of the trial, when the matter
I record your concern.
step, time may be given to conclude the trial. That's it.
The time ta mana kale aage.
Sir, no, if it will not be stipulated, my lord, what
Time stipulation ta apanku padhiବାକୁ ପଡିବ. Para 42-43 of the Constitution,
my lord,
where 5 honorable judges univocally has said, so Constitutional Court cannot do it.
no, if that will not
Tar
be
reason
done,
kon
sir,
janchandi?
If that
तार reason आपण जो logic दउचंती ସେଥିରେ Supreme Court भी has given very simple logic. The cases where the parties are not before the constitutional court, they are not lesser mortals. ଆପଣଙ୍କର ଯଦି ଆପଣ ଏଇ ଯୋଉ ଆର୍ଗୁମେଣ୍ଟ ଟା କରୁଛନ୍ତି ଟାଇମ ଦେବେ ଯଦି ଗୋଟିଏ କେସ୍ ପେଣ୍ଡିଂ ଥାନ୍ତା ତା ପୂର୍ବରୁ କିଛି ପେଣ୍ଡିଂ ନଥିବ କି ତା ପରେ ନଥିବ ତାହେଲେ ହବ. What is the answer? How the court can pick up a particular matter because Mr. Patnaik and Mr. Rathar appear? ଆପଣଙ୍କର ବି 10ଟା ମ୍ୟାଟର ଥିବ ନା ନାଇଁ ଗୋଟିଏ ମ୍ୟାଟର ଅଛି କୋର୍ଟରେ. So that is the concern of the Supreme Court. That picking up a particular matter because party has come to High Court or Supreme Court cannot.
with the folded hand, I can.
अरे hand court को कौन होगा आगे?
The two matters are there. One CRP and one CP. When the CRP started.
ଆପଣ two matters मैंने बुझी पालेनी.
No, sir.
You as a lawyer, you are having so many cases.
No.
So though
I am specifically submitting my point in particular case.
आज्ञा पढ़िले हबो ना आपण तो पढ़ी नांती.
Two.
पारा 42 रे कोन कहले कन्स्टिट्यूशन में
Sir, ମୁଁ ଏଇ କଥାଟା
से कथाटा से कहचंती. When you get a chance, you argue that point before the apex court. जे 5 जन बेंच 7 जज को रेफर हो. मु अपन डायरेक्ट सेटा लॉयर को से प्रेरोगेटिव अछि. You can always argue that the constitution bench decision to be revisited. But how the High Court will revisit that?
Lord, my humble submission with
Move on, humble
petitioner.
Sir, both of us are humble. That is how I am saying that I cannot revisit a Supreme Court constitution bench decision. Seta apanakar the reason is valid actually. Whoever comes to High Court, he will get a order that tanko case ago niya jibo. That cannot be. That is per se discriminatory.
Two cases filed by the person.
Apanako jo anxiety
One
affidavit, I am not passing anyone.
One CP and one CRP. In CRP, she has read the evidence and trial concluded and award was granted to.
Pursuant to the observations made in the order dated 21/5/2026, after hearing the learned counsel for the petitioner as well as Mr. Chotra, I said Mr. Rathar, sorry. Chotra and Mr. Patnaik for the opposite party. The petitioner files affidavit before this court, undertaking before this court in the form of an affidavit. Stuff. The contents of affidavit are irrelevant for the adjudication of the present matter to the extent that it deals with who will be the witness, as this court cannot direct in a pending trial as to who can be a witness before the trial court. As observed by order dated, the affidavit is taken on record. As observed by order dated 21/5/2026, the present petitioner responded before the Lord Judge Family Court should be given another chance for which she is required to file affidavit, for which she shall appear on. तारीख दीजिए. अरे आपण तो जोटा जोटी पाए affidavit दवा का देलेनी. It has to be rejected. The petition should be dismissed.
That's it. On the
कोण बुझले कोण आपण
date fixed on the date fixed, I will.
No, you file affidavit.
It's
लिखंतु सेटा हाथ लिखंतु shall appear on एते. मु सेति पे भी कंसल्ट करे कहली मिस्टर पटनायक से कहला राज्य ले को दिन अपियर कले हो को दिन अपियर कले हो लोअर कोर्ट वेकेशन आगे हबो सरीबो डिस्ट्रिक्ट कोर्ट रे 17 रे खोलिबो 19 रु छुट्टी हेलानी 19 रु छुट्टी हेलानी 17 रे खोलिबो को दिन अपियर करिवे मिस्टर छोटरा
25th years.
हला ठीक है 25
25th.
छाड़ दियंतु 5-6 दिन ने काई है
Bless.
तार कोडे वेकेशन में बुलावली करिवे on 25 July 2026. Sorry, 25 June 2026. On the state date, the learned court shall proceed with the examination as the petitioner is directed to keep the respondent petitioner hearing is directed to keep her witness ready to depose. Stop. Regarding further examination of witnesses, public recall, etc., this court expresses no opinion. The learned judge, family court shall proceed in the matter in accordance with law by force. Stop. By the stop.
Expeditious.
The parties are directed to cooperate in expeditious disposal of the proceeding as it is, as the learned counsel, Mr. Patnaik for the opposite party expresses concern that the matter is kept pending. That's the point. Actually, but anyway, the matter is kept pending, and the petitioner, after not adducing after not completing the petitioner hearing, has responded. Having not completed her evidence for the last 2 years, has been given a reprieve by this court by allowing her to complete her evidence. ସେଇଟା ତ ଆଜ୍ଞା ଆପଣ ତ ପିଟିସନ ଫାଇଲ କରିବେ, ଡାଇରେକ୍ସନ କଣ ଦରକାର? ଆପଣଙ୍କର ମିଷ୍ଟର ଛୋଟରାୟଙ୍କ ମ୍ୟାଟରରେ ସିଏ ଆଡଜର୍ନମେଣ୍ଟ ଦେଲେ ଆପଣ ପାର୍ଟି ମନା କରୁଛନ୍ତି, ସେମିତି ଆପଣ ଆଡଜର୍ନମେଣ୍ଟ ଦେଲେ ସିଏ ମନା କରୁନାହାନ୍ତି. There is a practical aspect to it. Why the petitions are not filed? Because CPC is very clear. If the petitioner appears, respondent doesn't appear. Respondent appears, petitioner doesn't appear.
One petition
So ଆପଣ ଫାଇଲ କରିବେ, କୋର୍ଟ ଅର୍ଡର ନ କଲେ ଏଠିକି ଆସିବେ. ସେଇଟାରେ ଶୁଣନ୍ତୁ,
Sir, 10 ବର୍ଷ ହେଇଗଲାଣି.
ଏଠି lawyers are overburdened, the system is overburdened. ଆପଣଙ୍କର ଯୋଉ ଦିନ ଆପଣଙ୍କ ଏଭିଡେନ୍ସ ହେଲାନି, କଣ କୋର୍ଟ ବସିକି ରହିଲେ? ଅନ୍ୟ ମ୍ୟାଟର ଟେକ୍ ଅଫ୍ ହେଲା. That is the reason. The impression is given that court is giving date. Actually, court is not giving date. Court is continuing its work. Maybe convenience of the parties or the lawyer or whatever is happening. Yes. Yes, next.
Item A.
Mr. Manomohan Patnaik for the petitioner. Yes, Mr.
May I please, Your Lordship?
Yes, please.
Division application, transfer application against the impugned order is CRP number 20 of 2026 of Judge Family Court, Raulkela, Bhubaneswar. Because earlier in the application, he, the petitioner, has already filed initial proceeding before the Learned Family Judge Bhubaneswar under section 13 of the Hindu Marriage Act. The respondent wife, without appearing before this court, approached this honorable court, wherein application of annexure 2 by order dated 23/2020, the further proceeding was stayed at Bhubaneswar. The matter is pending, outing the orders. What happened thereafter? The respondent, by pretext of some arrangement, she went to Raulkela and he was employed under the High Tech Medical College. Prior to that, he was
employment is a pretext. Seটা High Court କହିବେ.
No, my lord.
ଏଇଟା ହେଲା ଥାର୍ଡ. ଜଣେ କହିଲେ ଯେ ସୁପ୍ରିମ କୋର୍ଟ ଅର୍ଡର କଣ୍ଟ୍ରାରି ଦିଅନ୍ତୁ, ଆଉ ଜଣେ କହିଲେ କନଷ୍ଟିଟ୍ୟୁସନ ବେଞ୍ଚ କଣ୍ଟ୍ରାରି ଦିଅନ୍ତୁ. ଆପଣ ବର୍ତ୍ତମାନ କହିଲେଣି I will record in the pretext of employment she has gone to Raulkela.
No.
So the case has to be transferred from Raulkela.
My lord, that is my whole intention to submit.
No, your intention is recorded also.
My question, my submission is, she is a permanent in evidence of Bhubaneswar. Her parents are there. She got married in Bhubaneswar.
ଦେଖନ୍ତୁ provision ପଢନ୍ତୁ. Provision କହିଲେ permanent resident, parents house, marriage. କୋଉଠି ସେଟା ଅଛି?
In the Marriage Act, marriage has been taken place. Profound respect, I am telling you.
Sir, am I not respectful? I am also very respectful. So respectfully, I am requesting you to refer to law. It is not a debate competition. Like I used to do
with all
debating.
With all humility, I am telling you, Lordship.
Sir, I am also humbly saying, sir, refer to law, sir. Let us read the law.
Yes, I don't go back to
that.
No, I am not reading out from the law.
No, the wife cannot file at where she resides.
No, she can file. Actually, she filed. Only to avoid to appearance, made
Sir,
her appearance at Bhubaneswar court.
Individual perception cannot be taken note by legal proceeding.
No, that is not my submission.
সেটা ମୁଁ ଲେଖିଲେ ମୁଁ ମତେ ବହୁତ ଭଲ ଲାଗିଲା actually ଆପଣଙ୍କର speech ଟା. If I reproduce that, that will be nonsense.
That
The
is not
judge
my
should not be
intention.
like-
Lordship, that
like-
is not
like
my
the Supreme
intention.
Court says,
My intention is very clear because he has a very emphatically.
ଇଏ ଆସିନାହାନ୍ତି ଆପଣ you are so concerned why you have filed 13. ସିଏ କଣ ଫାଇଲ କରିଛନ୍ତି 125 ନା 9?
So 125 Bhubaneswar file କଲେ କିଛି ଅସୁବିଧା ନଥିଲା ମୋର. Because he will file, he said.
ଆଜ୍ଞା 125 ଏପର୍ଯ୍ୟନ୍ତ ମୁଁ ଗୋଟିଏ ବି ଡିଲ୍ କରିନି. ଆପଣ ଯୋଉଟା ପ୍ରେୟାର ଆଲାଉ କରିନି ଆପଣଙ୍କ ପ୍ରେୟାର ଲାଷ୍ଟ 5 ବର୍ଷ ଭିତରେ ଆପଣ ପ୍ରୋବ୍ଲେମ ହେଲା 125 ଯୋଉଟା କହୁଛନ୍ତି ନହେଲେ 144 କୋଉଟା ଫାଇଲ ହେଇଛି?
No, 125.
25 ଫାଇଲ ହେଇଛି.
CRP 25
jurisdiction କୋଉଠି ଅଛି? jurisdiction କୋଉଠି ଅଛି? law କୁ ଆସନ୍ତୁ. ଆପଣ ଯାହା କହିଲେ ବହୁତ ଭଲ ଲାଗିଲା. come to law. କୋଉଠି jurisdiction ଅଛି 125?
The court of the family house where she resides.
ପଢି ନାହାନ୍ତି ସାର୍ କୁ ସିଆରପିସି ଦିଅନ୍ତୁ ସାର୍ ବାହାର କର.
But I have read your lordship. 125 is interim maintenance.
ନାଇଁ ନାଇଁ ଆପଣ ଆମର let us come to law sir.
Yes.
ଆମର ଏଥିରେ କଣ ଅଛି?
Yes.
Debate ହେଲେ ତ I will score better marks than you. I am not debating. Come to law sir.
Yeah.
125 ର କୋଉଠି jurisdiction ଅଛି? କୋଉ ବହିରେ ଅଛି? କୋଉ provision ରେ ଅଛି?
The provision ତ ଅଛି your lordship.
କୋଉଠି କୋଉଠି?
ଦେଖୁନାହାନ୍ତି only 125 order of
ଠିକ ଅଛି, let us
maintenance
not
by
waste time.
children and parents. That is the
Sir,
very
jurisdiction
proper.
ଟା କୋଉଠି ଅଛି? jurisdiction ଟା କୋଉଠି define ହେଇଛି? 125 ରେ.
Where the defendant resides.
ନାଇଁ
The civil court is clearly.
ସେଇଟା ଆପଣ ଅନ୍ୟ ମୁଁ actually ଭାବିଲି section 9. I am sorry. ଆପଣ ଯେତେବେଳେ ଆରମ୍ଭ କଲେ ଏତେ emphatically ସେଠି ମତେ ଲାଗିଲା ଏଠି 13 ସେଠି 9 ଫାଇଲ କଲେ. So ଆପଣ
9 file କରି-
ନାଇଁ
9 has not
ଅଛି
been
ସାର୍ ଅଛି ବ୍ୟସ୍ତ ହୁଅନ୍ତୁନି 126 ପଢୁ.
126 ପଡି 125 ପୁରା କୋର୍ଟ ଗଲେ.
ନାଇଁ 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 ଆଜ୍ଞା ଆପଣ ତ ପଢି ନାହାନ୍ତି 126 ପଢିବେ ଅସୁବିଧା ପାଇଯିବେ. 126 ପଢନ୍ତୁ ପାଇଯିବେ ସେଇଟା.
Procedure.
Hmm.
Proceeding under section 125 may be taken against any person in any district.
ସେଇଠି
Whereas
ରହିଯାଆନ୍ତୁ
he is-
ସେ ରହିଯାଆନ୍ତୁ. Mark the language. Proceeding under 125 may be taken against any person in any district. ଆପଣ ତାକୁ କ୍ୱାଲିଫାଇ କରିଦେଲେ ବାପା ମାଙ୍କ ଘର ବାହାଘର ହେଇଥିଲା ଆଉ ଗୋଟେ କଣ କହୁଛନ୍ତି ମିସଚିଫ ନା ଗୋଟେ କଣ
No, 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 no.
ସୋ ଆପଣ
ସେଠି ତା in-law house ଭୁବନେଶ୍ୱର.
ହଁ
ତାର in-law house ଭୁବନେଶ୍ୱର.
ସେଇଟା
You're getting married.
ସେଇଟା 126 ରେ ନାହିଁ.
That is
Rather,
my point.
126 is a very unique provision. Any person in any district. The reason being, the court, the purpose of this 125 is that the wife can file it anywhere.
I am not disputing your lordship.
No, don't dispute. So I am not so because when you do not dispute law, so I will dispose of only with a direction that if possible you will file by ICT.
I will submit why I am coming. Why
Sir,
I
it's
am
a
coming.
illegal
I don't
order
want to
coming.
waste the
No, no,
valuable time of my lord.
Sir,
Because
Because I cannot violate 126 or I cannot violate 126. So that is how you do not find any case law on 126. It will be transferred where the husband lives or where the matrimonial home.
no, the predicament of the husband is
ଆପଣ ଶୁଣିଲେ ମୁଁ କଣ କହିଲି?
ମୁଁ ସବୁ ଶୁଣୁଛି.
କଣ କହିଲେ? ICT ର full form କଣ?
ଆଜ୍ଞା।
ତ
ମୋ କଥା ମୁଁ
when you
କହୁଛି
do
କୋର୍ଟ
not
କଥା ମୁଁ
listen, ଆପଣ ନ ଶୁଣିଲେ କିଛି ଜିନିଷ ଆପଣ ଫେଭର ହେବେ ଆପଣ ଯଦି ଚାହିଁବେ କୋର୍ଟରେ ପରମିଶନ ନେଇକି ରିମୋଟ ଲୋକେସନ ରେ ଆପଣ ଭିସି ରେ ଆପିୟର କରିବେ ସେଟା ଆଜ ପର ରୁଲ ସେତିକି କରିପାରିବେ.
ଆଚ୍ଛା
ହଁ ସରିଲା?
କରିପାରିବି. ମୁଁ କହିବା ସାର୍ ମୋ କହିବା କଥା ଯେତେବେଳେ ସି ଭଲେଣ୍ଟାରୀ ଡେଜର୍ଟେଡ୍ ଦି in-law house.
ସେଟା ଆର୍ଗୁମେଣ୍ଟ ହବ 125 ରେ ଆପଣ ଭଲେଣ୍ଟାରୀ ଡେଜର୍ସନ ଆଉ ସେକ୍ସନ 9 ଆର୍ଗୁମେଣ୍ଟ କରିବେ.
ନାଇଁ ମୋ ସିପିରେ ପଡିବ. ସିପି ଇଜ stalled because of the pursuant to the direction of the honorable court of law. That is why I am before your lordship. Because the same self allegation, wife and husband.
Sir, let us discuss and understand law. Debate competition. ଆପଣଙ୍କ impressive debate. I am really impressed.
No,
But
no,
if I reflect that in my order,
that is not
my
my
order becomes nonsense.
intention. My intention, I must be protected.
ନାଇଁ
Or in not withstanding to go to the Ramtala because
ସେ ଆପଣ ଶୁଣନ୍ତୁ
observe.
ସିଏ ବର୍ତ୍ତମାନ ଯେହେତୁ ମୁନ୍ ଯାଉଛନ୍ତି ଧରନ୍ତୁ ସେ ମୁନ୍ ରେ ବି ଫାଇଲ କଲେ ଚଳିବ. ଓନ୍ଲି ସେଟା ହବ ଯେ ମୁନ୍ ରେ ଟେରିଟୋରିଆଲ ଜୁରିସଡିକ୍ସନ ଅଛି କି ନାହିଁ. ଆପଣଙ୍କ the language used is at against any person in any district.
I do oblige. I do oblige with the all respectful submission.
ଶୁଣନ୍ତୁ ସେଥିପାଇଁ
Submission is.
ଆପଣଙ୍କର ଯଦି ଯୋଉଠି ହଜବେଣ୍ଡ ଚାହିଁବେ ହବ କେସ୍ ଲ ଯଦି ଏପର୍ଯ୍ୟନ୍ତ ଡେଭଲପ ହେଇନି କାଲି ଯୋଉଟା କହିଲେ ମିଷ୍ଟର ରସିଦ କହିଲେ ଯେ ମୁଁ ଡେଭଲପ କରିବି
That is not
So
my-
now I will develop jurisprudence.
Emphatically,
Despite
and respect
126.
to submit that.
Yes,
Because
yes.
my case is
No,
strong.
no, but
Or
Mr. Patnaik, I'm telling largely to make it a lighter thing because you don't get overawed by the context. 126, I cannot evolve law that the matrimonial home जोटी से जोटी रहउथिले सेठी हबो. आपण जदि भी सुनतु आपण केस जितियो ना हारियो चाहउछन 125 पे. आपण तो जितियो चाहउछन.
The 120 ମୁଁ file କରିବି. The wife is filing.
ଆରେ ଆପଣ ଆଜି ଅପୋଜିଟ ପାର୍ଟି ଜିତିବେ ନା ହାରିବେ?
The opposite party ଜିତିବ ଆମେ maintain
ଆପଣ ଜିତିବେ
ହଁ yes.
ତ ଆପଣ ମେଣ୍ଟେନେବିଲିଟି ପ୍ଲେ ନେଇ ପାରିବେ ଏଠି କଣ ହବ ଏଠି ମୁଁ ଯେ ଡିସାଇଡ୍ କରିବି ଇଟ୍ ନଟ୍ ମେଣ୍ଟେନେବଲ୍ କଣ କ୍ୟାନ୍ ଆଇ ଡିସାଇଡ୍ ଆଇ କ୍ୟାନ୍
ମୁଁ ସାର୍ ସେଟା ବି କହୁନି ମୁଁ କହିବା କଥା ଯଦି ଭୁବନେଶ୍ୱର ଗୋଟେ
ଆପଣ ସାର୍ ଯାହା କହୁଛନ୍ତି
ଭେରି ସିମ୍ପଲ
I cannot terminate I'm sorry I cannot determine the Bhubaneswar court is the best place for 125 contrary to 126
no that is not my submission if your lordship is fixed fit and proper if it is not be Bhubaneswar bill I am unable because I have lost my entire career as a husband because of my wife.
Again, career re build up करंतनी husbandship रे so that will be disastrous recipe.
No.
आपणकर
Disastrous.
से आपणकर professional career पड़ेला.
Exactly. She lost his service. Everything. She has lost the reputation in the society.
सेटा WS रे लिखिबे.
ମୁଁ WS लिखिचे ଦେଇଛି
देबे कोन.
ମୁଁ ଦେଇଛି ଆगे जो
ଏଠି ତ pending ନାହିଁ. सेठी देबे 125 रे WS रे देबे सेटा भी that is a 120 as I find 125 is a complicated
No.
I try to say in a one sentence.
My humble submission before the RCB, only one more time will take. Let the matter. TRPC 436/2025, which is filed by the respondent wife. And this TRPC shall be clubbed together, shall be clubbed to my
togetherness in maintenance and
no maintenance.
CP togetherness
for application
from
transfer to Hon'Ble.
अरे ठीक है आपण जेतेबेले गोटे फोर्सफुली कहउछन किछि सुनु ना आपणकर सीपी फाइल करछन्ती आपण
मु सीपी फाइल कर
आपण हस्बैंडशिप कैरियर रे बर्तमान आपण चाहे सीपी फाइल करछन 13 रे सेठी भुवनेश्वर रे
आज्ञा
हां सीए 125 फाइल करछन
नो सीपी कोइ बे कहउछि से एके टीआरपी फाइल कला सीपी टा ट्रांसफर ओवर Hon'Ble दैट इज व्हाई आई एम बिफोर यू राइट नाउ
आपण सब कथा नो न बुझी कहउछन ଆପଣ 125 ଆପଣ ଟିକେ ଶୁଣନ୍ତୁ I am very sure that you are not listening anything and God has given human beings to listen and understand to speak and understand ability ନାହିଁ ଆମର ନାଇଁ ନାହିଁ ତ ମୁଁ ତ ବି ବୁଝି ପାରିବିନି କହିକି I have to hear you maybe I am little bit faster ଜଲ୍ଦି ବୁଝି ଯାଉଛି ସେଟା ଅଲଗା କଥା କି ବୁଝି ପାରୁନି ସେଟା ଗୋଟେ ଜିନିଷ ଆମେ ଆଗରେ କିଛି ବୁଝି ପାରୁନା that's a good thing ଆପଣ 13 ଧାରା फाइल कले भुवनेश्वर रे सी फाइल कले 125 धारा राउरकेला रे 13 ट्रांसफर पे से फाइल करछन राउरकेला रे हां एला करछन
एटा
स्टे हबनी कोन हबो सिटु स्टे हबनी हाई कोर्ट कोन माने जोठी 125 फाइल स्टे ही परिबो ना
सते मु आइदर आई विल नॉट एबल टू कन्विंस
माने बुझेइछन्ती आपण एते बढ़िया बुझेले मु संगे संगे सब बुझी कहूची
तथापि आहुरी बुझिया मत अछि
नाही
कहया कथा सिए
125 रे
फाइल कले
सर आपण को मोर ऑर्डर पूरा ऑर्डर उडा को इज बाइंडिंग ऑन मी मोर 20 30 टा ऑर्डर हे गलानी पण तो चैलेंज करे पड़ो सुप्रीम कोर्ट
आई एम सॉरी टू से आई अप्लाई टू योर लॉर्डशिप
I cannot deviate from my orders 125 126 रो जो jurisdiction ता I cannot dilute that
मु सर ता भी कहू नै मोर ता भी सबमिशन नुहे जे आपण कोर्ट विल डाइवर्ट योर ओन जजमेंट ऑफ प्रोसीडिंग माय सिंपल सेइंग
आपण कहिले I will reject that पण जदी सेटा कहबे आपण बुझी पाले नि ताले since 125 matters I have taken a view and consistently I have been following that I will not transfer 125 I have interpreted that provision
that is not my submission because so far this CP is
I'll dismiss your application
no my that is
not 125 अपन ट्रांसफर चाहू नाहंती I'll dismiss
your lordship has a jurisdiction to direct me to appear in the BC at Bhubaneswar
कहली सेटा आपण आईसीटी बुझी पालेनी फुल फॉर्म पचाले आपण जे सबले कहले जे मु सब सुनुची
no
आईसीटी फुल फॉर्म कोन इंफॉर्मेशन कम्युनिकेशन टेक्नोलॉजी आईसीटी पैराग्राफ रहइबो सी भी अपेयर करिवे आपण भी अपेयर करिवे डिफिकल्टी नाही
ठीक है
That, yes.
आई ऑब्लाइज
Yes, transfer kari habani. Upon transfer, thankfully, one order of mine in maintenance has been tested by Supreme Court, and Supreme Court has thought that it is a judgment, has passed order that the judgment is confirmed with reasons. So that is, but so 125, 126 are actually somehow the statute is very clear against any person in any district. The reason being that because husband can also file 125 or not. Husband can also file. At least one petition I have dealt with.
yes
So that is a purpose. Because the person who is in distress, 125.3, you read Justice Krishna's judgment, he has elaborated. It says 15.3, Article 15.3 gone. The state can make any provision for women and children. 125 is older than at least Hindu Marriage Act. And it is applicable to all persons, irrespective of the religion. So there is a purpose. Kahin 126 re karaichi against any district because a person who is in distress is seeking financial assistance. Upon jodi taku section 17 bharti kar debe. In fact, you started arguing section 17. That is how I thought it is a section 9 application.
Stress. Actually, 125 is applicable.
ଆପଣ deny କରିବେ. ଆପଣ deny କରିବେ written statement ଦେବେ including territorial jurisdiction ନାହିଁ ବୋଲି. That's a different thing. But yes, yes.
The permitting the petition.
Yes, I am quoting that provision. 125, 126 तापरे last रे ICT information and communication technology जदि permissible थिबो से देबे. Yes. Oda kali sita se order ta reproduce hobo. The hard lawyer counsel for the petitioner at length. The petitioner is the husband in the marriage. He is before this court seeking transfer of CRP number 20 of 2026 of CRP number 20 of 2026 pending before the Lord Judge Family Court Raurkela to the court of the Lord Judge Family Court to the Lord Judge Family Court 1. Mr. Patnaik,
sir,
से मैटर टा केबे पुरो होइछ?
stay
अरे नोटिस रे आपण अपियर करचंती?
good happy good.
But এটা কাই মুভ করছেন?
রাউরকেলা appear করছি
নাই ম হাই কোর্ট
appear করছি কাউন্টার রে ফাইল করে দিয়েছি. This T1 bench is not a coordinate bench now.
তাহলে এটা কাই মুভ করছেন?
এটা মোর my intention is for which I am
শুনুন again ফেরে কইবা আরম্ভ কলে
আজ্ঞା
ସବୁବେଳେ ଶୁଣିବେ ତାହେଲେ ବୁଝିପାରିବେ.
ଆଜ୍ଞା
ଆପଣ ଏଟାକୁ ମୁଭ୍ ନ କରିକି ଅପେକ୍ଷା କରନ୍ତୁ. ସେ ମ୍ୟାଟର ଯେତେବେଳେ ଟେକ୍ ଅଫ୍ ହବ ସେତେବେଳେ ଏଟା ଟେକ୍ ଅଫ୍ ହବ.
ସାର୍ ସେଠି ପୁରା ମ୍ୟାଡାମ ସାର୍ ସେଠି ସେ ମ୍ୟାଡାମ ଯିଏ ଅଛନ୍ତି ସେ नो यू पर्सनल आपियो
ସେଇଟା ସେଠି ଯେ ମ୍ୟାଡାମ ସେ ଆମେ ତାଙ୍କୁ ଏଠି ଯୋଉ ସାର୍ ମ୍ୟାଡାମ ଅଛନ୍ତି ସେଠି ସାର୍ ମ୍ୟାଡାମ କହୁଛନ୍ତି ଡିସ୍ପୋଜ କର. ସୁପ୍ରିମକୋର୍ଟ କହୁଛନ୍ତି ଯେ ମେଣ୍ଟେନାନ୍ସ କେସ୍ କାହିଁ ପେଣ୍ଡିଂ ରହିଲା. ନାଇଁ ବଟ୍ ଆପଣ ସେଟା ଲିଷ୍ଟ କରିବାର ଥିଲା. ତ ଆଜି ଅର୍ଡର କରିବି ନା ନାଇଁ ଆର୍ଜନ କରିଦେବି?
ମତେ ବିସିରେ ଆପ୍ଲାଏ କରି
ଶୁଣନ୍ତୁ ସାର୍ ଆପଣଙ୍କର ଯେତେବେଳେ ଟ୍ରାନ୍ସଫର ଆପ୍ଲିକେସନ ଆପଣ ଗୋଟେ ଫାଇଲ ସିପ୍ କରିଛନ୍ତି ଆପଣ ଗୋଟେ କରିଛନ୍ତି ସୋ ୟୁ ହାଭ୍ ଏ କେସ୍ ଟୁ ଆର୍ଗ୍ୟୁ ଟୁଗେଦର ଅର୍ ନଟ୍?
That is my sole intention.
ତାହେଲେ ଆପଣ ତ କହୁଛନ୍ତି ମୁଁ ଏଇଟା ଆଜି ଅଲଗା ମୁଭ୍ କରିବେ. ଆପଣ ସେଟା କାହିଁ ଲିଷ୍ଟ କରୁନା?
ମେମୋ ଦେଇଛି ସାର୍ ମୁଁ ମେମୋ ଅଲରେଡି ଦେଇଛି that could not be taken because coordinate bench is not available.
କୋର୍ଟରେ ରିଜନେବଲି କେସ୍ ଲିଷ୍ଟ ହଉଛି. ମେମୋ ଦେଇଛନ୍ତି ମୁଁ କହିପାରିବିନି ସେଟା ହେଇପାରେ. ଆଇ ମେ ବି ଆମର କେତେଟା ମ୍ୟାଟର ଲିଷ୍ଟ ହେଇପାରୁନି ସେ ସମାଧାନ କରିହଉନି. ବଟ୍ ଆପଣ ଏଇଟାକୁ ଇଣ୍ଡିପେଣ୍ଡେଣ୍ଟଲି କାହିଁ ଆର୍ଗ୍ୟୁ କରୁଛନ୍ତି?
Because this matter has
because when ଆପଣ ଯୋଉ ପଏଣ୍ଟଟା କହୁଛନ୍ତି that will be forcefully argued when other matter is taken up the petitioner there who has obtained stay in your proceeding she is present maybe possibly ଆପଣ କଣ ଚାହୁଁଛନ୍ତି ବହୁତ ଦିଟ ଜାଗା ରାଉରକେଲା ପଳେଇବ? ଆପଣ ସୁବିଧା ହବ?
Your lordship that will be discussion. I cannot say. I cannot impose upon the
other. ମୁଁ ତ କୋଉଠି I am not taking. I am not discussing with you. ସେ ମ୍ୟାଟର କଣ ମୋ ପାଖରେ ଅଛି? ଆପଣ ଏଇ ଯୋଉ ମ୍ୟାଟରଟା ଏଇ ଯୋଉ ଟିଆରପି ସିଆରଏଲ ଟା ଆପଣ ଇଣ୍ଡିପେଣ୍ଡେଣ୍ଟଲି କାହିଁ ଆର୍ଗ୍ୟୁ କରୁଛନ୍ତି ସେଟା ମୁଁ ବୁଝିବାକୁ ଚେଷ୍ଟା କରୁଛି. ମୁଁ ଅର୍ଡର ତ ପାସ୍ କରିଦେଇଛି ମୁଁ ପାସ୍ କଲା ପୂର୍ବରୁ ଫାଇନାଲି ଆଇ ଏମ୍ ଟ୍ରାଇଂ ଟୁ ଏକ୍ସପ୍ଲେନ୍ ୟୁ ଦ୍ୟାଟ୍ ଇଫ୍ ୟୁ ବୋଥ୍ ଦ ମ୍ୟାଟର୍ସ ଆର୍ ଟେକେନ୍ ଅପ୍ ଟୁଗେଦର ମେ ବି ୟୁ ହାଭ୍ ଏ ବେଟର ଚାନ୍ସ ଅଫ୍ କନଭିନ୍ସିଂ ଦ କୋର୍ଟ.
That is my entire intention. Till then my interim order may be I may be protected. Dita ko club of hijaw. ଆପଣ କୋଉଠୁ ଆସୁ ମୋର ଆପତ୍ତି ନାହିଁ ମୁଁ ଆଇ ୱିଲ୍ ଆର୍ଗ୍ୟୁ ଦି ମ୍ୟାଟର ଏଣ୍ଟାୟାର
ସେ ଫାଇଲଟାକୁ Order copy kai.
Annexure ଦେଇଛି annexure your lordship kindly see order annexure 2 at page 18 TRPC court petition of 2025
Just one. Kindly take yours.
Okay.
Last. CP সেটা কোন CP CRP ହେଇଥିବ ହଁ CP ନୁହଁ CRP number 20 of 2026 pending before the learned judge family court Raurkela ହେଲା. The said CRP has been filed by the wife in the marriage under section 125 of CRPC oblique under section 144 of Bharatiya Nagarika Suraksha Samhita 2023 Ara. It is submitted that the opposite party wife has filed CRP number 20 of 2026. The CRP no, the opposite party no, the husband petitioner. The present petitioner has filed CP number
608 of 2000
कोटी कहउछन सेटा अछि को पेज रे 600
page kindly your lordship kindly turn to page 18 continue running page
CP number 608 of 2025
ଆଜ୍ଞା
under section 13(1)(1)(a) 13(1)(ia) Roman IA pending before the learned judge family court
One
Bhubaneswar seeking dissolution of marriage solemnized between the parties and decree of divorce stuff. The said in the said TRPC 436 of 2025 no sentence भूल है आउथरे पढो सेट काट दे पूर्वटा and decree, not degree, and grant of decree of divorce. Stop. The opposite party wife has filed TRPC number 436 of 2025. Seeking transfer of the said CP pending at Bhubaneswar to Raurkela. Sir, prayer कौन कर अपन petition नहीं मुझे जानी अपन जा करेंगे after that.
ସେ ପିଟିସନ ଏଣ୍ଟାୟାର ପିଟିସନ ଦେଇଛି
कोड देखो कोड जे ट्रांसफर प्रेयर करछे
ସେ ରାଉରକେଲା ଚାହୁଁଛନ୍ତି ସେ ରାଉରକେଲା ବିକଜ
ଆପଣ ଜାଣିଲେ କେମିତି ସେଥିରେ ଆପଣ କଣ ଆଫିୟର କରୁଛନ୍ତି मनमोहन पटनायक राइट
she has taken the arguments in the entire petition that she is working at a high-tech hospital
कोठी
राउरकेला
ट्रांसफर कोठी की चाहुचंती
ସେ ସେଠି ଅଛନ୍ତି ବୋଲି ସେଇଟା ଯେହେତୁ ଫ୍ୟାମିଲି କୋର୍ଟ ଫାଇଲ କଲେ
लेखिले कोर्ट लेक्चर
ମୁଁ ଲେଖିଛି ମୋର ଏଣ୍ଟାୟାର ଆଭେଲେବଲ୍ ଲର୍ଡସିପ କାଇଣ୍ଡଲି ଫାଇନ୍
कोठी आज्ञा देखना
kindly my synopsis your lordship kindly visualize
या सिनॉप्सिस रे कोठ मिलबा आज्ञा तांकर प्रेयर कोन आपण कहले आपण सिनॉप्सिस देखिबी
more statement I have not stated any wrong information to the honorable court
ये पचा की कहले आपण राइट इंफॉर्मेशन देचंती कि नहीं क्वेश्चन होची जे कोठी ट्रांसफर चाहुचंती आपण कहउछंती मो रॉन्ग इंफॉर्मेशन दे तार कोन ई आंसर
से चाहूं
रॉन्ग इंफॉर्मेशन कोन जगह रा ना को जगह को कोर्ट
से राउरकेला कोर्ट फैमिली को जज बिजनेस गोटे कोर्ट अछि सेठी जिबे तार उद्देश्य सब सेठी जाबे सेठी फाइल करले त कोन मो आई विल प्रोड्यूस ऑल द रिलेवेंट डॉक्यूमेंट्स
पेज 26 देखो कोन निजे खोजिबे नहीं मते खोजी बाहर करे पड़ो पेज 26 देखो कोन लिख the set CP 608 of the set CP 608 of 2025 to the court of learned judge family court Raurkela paile
भैया 26
Rourkela. It is submitted that by interim order dated 23/12/25 passed by the coordinate bench in the TRPC, the following direction has been issued. Para 5 ta quote kar debe. Para 5 paibe page 18. Page 18 next shot ki. It is submitted that the said TRPC has not been listed thereafter. In the interest of justice, the present TRPCRL as well as the TRPC should be taken up together. Accordingly, it is directed the TRPCRL number 430, the present TRPCRL as well as the TRPC number 436 of 2025 shall be listed together in the for fresh admission in the week commencing on 3/6/2026. IA 133 of 36 of 20. और कौन बोल आइए कितने आइए 36 of 2026 अब अगर प्रथमे टीआरपीसी फाइल कर देइथिले सेटा कटा है कि
आगे
कटा कटी है आइए 36 of 2026 as an interim measure it is directed that the CRP number 40 of 2026 pending before the Learned Judge Family Court Rourkela shall be adjourned to a date beyond 33 को अपन रखिले beyond 6/7/2026 as would be convenient to the Learned Court in season of the matter upon a prayer being made for the said purpose. Yes. सेठी आपण अपियर करी प्रेयर करिया पड़ियो ब्लैंकेट स्टे हे करियो आपण को एटा 29 रे आसीबो दिटे जाक सेटा 6/7 रे आपण जदि टिके जदि कम कहि थांते मुटी जल्दी बुझी थांते. Yes.
Okay.
Item 9. But notice is नहीं. 29 रे जा हबो.
ठीक है.
ते आज से तो अछन नहीं. तुमसे मन पट नहीं करो. से भी आपण ना भूली गले. तीन थर चार थर कहले.
May I please, Your Lordship? On behalf of Tama Mishra, I place this matter, my lord. Lord, the petitioner is the wife seeking transfer.
Mr. You do not have power.
My lord, on behalf of Mr. Tanmay Kumar Mahanti, I place this matter, my lord.
I'm sorry, I forgot to read. Mr. Sahoo.
Akshay Kumar Sahu.
Mr. Ekki Sahu. Mr. Ekki Sahu on behalf of
Tanmay
K. Mahanti for the petitioner. Yes, please.
My lord, the petitioner is the wife seeking transfer of the CP number 26 of 2026 pending before the Learned Judge Family Court Bhadrak to the Court of Learned Judge Family Court Bhubaneswar. My lord, the petitioner is a young lady. Yeah, after there was a
How many criminal cases she has filed against the husband?
no, only 144 of the BNS
Pending at Bhubaneswar.
Bhubaneswar.
But take notice.
My lord.
Had Mr. Sahoo counsel on behalf of the purpose petitioner. The petitioner before this court is the wife in the marriage. She seeks transfer of CP number 26 of 2026 pending before the Learned Family Court Bhadrak to the Learned Family Court Bhubaneswar. Bhubaneswar. Na Khurda se kaha.
Bhubaneswar, not Khurda.
Khurda Bhubaneswar. Designation bhul laga katha hai.
Sorry.
To the Court of Learned Judge Family Court Bhubaneswar at Khurda.
माने खुर्धा
Sorry, Khurda at Bhubaneswar. Khurda at Bhubaneswar. Mr. Patnaik को सुनला पर आज गोटे पूरा मोर मिक्स अप हे गला. तो हाइट हे गला से जो कहले जे कोड ट्रांसफर हो से कहले आई हैव नॉट स्टेटेड एनीथिंग फॉल्स. अरे कोर्ट याबो कोड देखान तो सेटा. Because that petition is not there. Yes. It is submitted that after the marriage has gone into rough weather, the petitioner wife is facing difficulty. She stays with her parents at Bhubaneswar or works at Bhubaneswar.
No, my lord, she is staying with her mother, widow mother.
Stays with her widow mother at Bhubaneswar. She has filed a CRP number 196 of 2025 pending before the Lord Judge Family Court Bhubaneswar. Under section 144 of the Bharatiya Nagarika Sur BNSS, 2023. Stop. Issue notice along with this order to the opposite party. The issue notice to the opposite party along with this order. Requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within 3 working days. 5 working roster ଅଛି ନାଇଁ କି ଏବେ ଫାଇଲିଂ କେତେ 11 ରୁ 12 ଗୋଟେ ଘଣ୍ଟା
11 ରୁ 12
କେତେବେଳେ 11 ରୁ 12 ଭିତରେ ଫାଇଲିଂ କରେ within 5 working days. So the returnable date be fixed to 9/7/2026. The matter shall be listed in the week commencing 6/7 कर दियो तो 6/7/2026. The matter shall be listed in the week commencing 13/7/2026.
Aye, my lord.
Hard nodded counsel for Mr. Sahoo for the petitioner. He reiterates his submissions as noted above. Issue notice as above. Accept one set of process fee as well as postal requisites. The returnable date as well as the next date of listing shall be as directed above. As an interim measure, it is directed that the pending CP number 26 of 2026 pending before the Learned Judge Family Court Bhadrak shall be adjourned to a date beyond 20/7/2026 as would be convenient to the Learned Court in season of the matter upon a prayer being made for the said purpose. Then certified copy? Yes. Yes, please.
11.
May it please your lordship.
Yes, please.
Your lordship, the petitioner wife has approached this honorable court seeking transfer of matrimonial case number 84 of 2025 under section 9 of Hindu Marriage Act filed by the husband from the court of learned family judge cum civil judge senior division Sundargarh to the court of learned judge family court Dhekanal. My lord.
So how many cases she has lost against the husband?
Against the husband, she has lost 2 cases, my lord. One affair was lodged on 19/11/2025 and immediately after 1 month, this petition has been filed by the husband in Sundargarh.
He has no choice because he will be he and his family, they are entangled in criminal cases. 498A.
400A. 400A, wife is residing since 2023 in Dhekanal. Both parties are permanent resident of Dhekanal. And the husband has threatened her to kill. Thereafter, she lost this affair.
Threatened to kill was argued yesterday. So
No,
that what the High Court cannot take care of that.
No, I am not saying that. But my humble submission, your lordship.
Because now the difficult proposition is that if somebody is threatened to kill, the safest place is Cuttack. Yesterday was argued. So for you, safest place is?
Safest place is Dhekanal.
Dhekanal. So how can it be every day the place changes?
No, my humble submission is that Sundargarh.
Only if you take legal recourse to the threat, this court cannot consider.
No, I am the wife, my lord. I am the wife, and Sundargarh court has no jurisdiction at all because neither the marriage was solemnized there nor the parties last resided together. The husband himself confessed in his plaint that when he was in Bihar,
then why it is filed at Sundargarh?
Just the husband is working there. He is posted there. He himself stated.
Thank God that you have not argued to attack the wife or what?
No, my lord. That is his.
So in fact,
no jurisdiction at all there.
The court place was argued by Mr.
Your lordship.
Asif Jana, I think. That she feels threatened. That's a different thing. That's a cheating.
Yes. So Sundargarh court has no jurisdiction at all. It does not fulfill the criteria of section 19 of Hindu Marriage Act because neither they last reside.
Because you see, the other question is that in a section 9 application.
Yes, your lordship.
The wife wants to resumption of matrimony.
No, because she is apprehending. She is apprehending for her life.
But she doesn't file 13. Or
No,
filed
she has filed a domestic violence case, but she has not filed the divorce yet.
domestic case at where?
At Dekanal only. And both parties are permanent resident of Dekanal only.
Ms. Ruchi Rajgaria for the petitioner.
Yes, Your Lordship.
The learned counsel for the opposite party blank. The learned counsel for the petitioner. Hard learned counsel for the petitioner. It is submitted. Petitioner stop kar debe. The petitioner before this court is the wife in the marriage. She seeks transfer of CP number 84 of 2025 filed by the husband in the marriage under section 9 of the Hindu Marriage Act. You see, usually, one thing I completely disagree. Usually after 498, 13 is filed. But here he has filed 9.
He has filed 9, my lord, but
So
in her...
that cannot be taken exception. And since you are saying that yes, the wife doesn't want to resume the matrimony, that yes, that is the only consideration. But otherwise, by interdicting the proceeding in section 9, this proceeding will not solve any purpose.
So far as
Because
my
she
knowledge...
wants to resume the matrimony.
No, she wife...
If, please mark the word if. If she wants
My
to
apology,
not
ma'am.
so then only possibility is counseling.
Earlier, several
It
counseling
is
happened.
possible only in the family court, not before High Court. So the entire thing is frustrating the scheme.
Your Lordship.
Seeking transfer is the wife of the marriage. She seeks transfer of CP number 84 of 2025. Pending before the learned judge family court. Learned family judge -- civil judge senior.sr. division, Sundargarh. To the court. Dekanal jaunchandi.
Family court Dekanal.
To the learned family court Dekanal. The CP has been filed under section 9 of the Hindu Marriage Act for restitution of conjugal rights by the husband in the marriage. And after almost 20 years of marriage, right? 23 years, sir. It is submitted by the learned counsel for the petitioner that both the husband and the wife, they stay at Dekanal. They never resided at Sundargarh. So, now the petitioner wife is staying with her parents.
With her parents. Parental house.
And she finds it difficult to attend the case at Sundargarh. So it is further submitted that if the matter is taken up, CP is taken up by the learned judge family court Dekanal. It would be convenient for both the parties. Issue notice along with this order. So notice to the opposite party along with this order. Requisites for issuance of notice by speed post with proof of speed post with registration and proof of delivery. That will be filed within 5 working days. Returnable date be fixed to 7/7/2026. The matter shall be listed for orders in the week commencing 13/7/2026. Stop. Para. Aye. Hard learned counsel for the petitioner. She reiterates her submissions as noted above. Issue notice as above, accept one set of process fee as well as postal requisites. The returnable date and the next date of listing will be as directed above. Shall be as directed above. In the interim, it is directed that upon a prayer being made before the learned judge, learned civil judge, learned family judge, has come as civil judge senior division, Sundargarh. The CP number 84, the MAT case number 84 of 2025. CP liquid, the organ number used, the MAT case. MAT case number 84 of 2025 shall be adjourned to a date beyond 20/7/2026 as would be convenient to the learned court in season of the matter. urgent attachment copy as well.
Deeply obliged. My lord, I have also annexed the mediation proceedings at Annexure 3 also. Several mediation has also been done.
That is counseling. Counseling as
But
mediation.
she tried to save her marriage, but now it's beyond
different
repair.
concept. Mediation is completely different. Counseling is completely. Mediation is kind of a negotiated, but counseling is counseling the individual first. Yes.
Highly obliged.
And counseling is by the professional counselors.
Yes.
Appointed as per rules.
Yes, sir. Obliged.
Yes.
Item 12.
Your Lordship, for item number 12, I am for the petitioner insurance company. Your Lordship, I came to the petitioner insurance company, came with the
Your name, madam, is Tripathi.
Jyoti Pradeshini Tripathi.
Miss Jyoti Pradeshini Tripathi for the petitioner. Mr. Prem Kumar Mahanti, additional standing counsel for the OP number 1. You are challenging a order of a local adalat.
Again.
You know the limitations of interference. So why you on which ground you are challenging?
I may be submit your Lordship. Your Lordship, my total case in Northsel is that as the insurance company, I have issued a material policy. 1 minute, Your Lordship.
Madam, you are not arguing an
Standard
appeal actually. The problem is that you have started arguing against your own case. This is not an appeal. Usually, if it is a motor accident claim,
No, Your Lordship.
workman compensation, what kind of claim?
Your Lordship, petitioner is a. I have.
What was insured or no, don't worry. Don't worry. Don't be anxious.
Your Lordship,
You are having absolutely no difficulty in addressing. Please
Okay.
don't be anxious. Don't get overawed or overburdened. So what was the claim for the insurance company?
Your Lordship, insurance company issued a standard fire and special perils policy material damage to a
It's a fire.
Bhubaneswar.
Is it a fire insurance?
No, Your Lordship. It is Bhubaneswar poultry farm.
Poultry.
Ji.
So you insured the chicks.
Yeah. Chicks, eggs, and every material damages, but the total loss is occurred in time of funny. Funny time रे जो loss है सेरा सेमाने inform कला परे हमें से उनसे step नहीं थी Your Lordship. We have deputy surveyor. We got the surveyor report, and as per the surveyor report, total 9,03.14 हमें surveyor report असला. And after deducting the 3,014 as the reinstatement of policy, we have settled the amount in 9 lakhs. In fact, we have also offered it. They accepted it. That is in his discharge voucher. We have given the money. Seman discharge voucher or a cancellation check, which is under Annexure 4 series, Your Lordship. Without any coercion, material fact, nothing else. They have accepted it and deposited the amount. They have also taken the amount. But further, they have claimed 8,13,000 for the claim in the PLA through a case PLA number 114/13.
So did you to register that claim before the PLA? Did you bring this aspect to the notice of the PLA?
Your Lordship, we have filed this case. We have no other case policy, Your Lordship. That's why we come to the writ petition. Because we have, in case the order was out of the PLA.
That's not the question. When the party, after accepting and settling the matter by accepting 9 lakhs, the insured, he again appeared the permanent local adalat claiming another 8 lakhs. So you appeared before the PLA?
Again.
So what was your stand? Did you apprise that it is already settled?
Yes, Your Lordship.
So kindly show that.
Through our written petition, that WS, Your Lordship, we have also stated this amount and fact that we have already settled the amount. Annexure number 3, Your Lordship. Annexure 3. Sorry. Annexure 2. I beg your pardon, Your Lordship, it's Annexure 2. Written version filed by the Oriental Insurance. Running page number 23.
And there, in fact, I'm looking at what you should look at. Paragraphs 4, you start looking at page 24, paragraph 4. Now I'm at paragraph 9, but you start looking there. how they have dealt with,
Again,
how the court has dealt with that. Whenever you are arguing a appeal or a writ petition, look at the pleadings. What is the case? You have very well argued the point actually. There was insurance. You have not repudiated the insurance claim. There was an incident of natural calamity. Then there was a survey. Survey report is there. Both of you have accepted survey report. Then you have paid the amount. And he has signed the discharge voucher also.
again.
After that, there is a parallel proceeding in PLA. So PLA, what is your stat? So para 4 to 7. Now, how the court has dealt with that?
Your Lordship, as per the Supreme Court order passed in United India Insurance versus Ajmer Singh, Cotton and General, there is a placetum, Your Lordship, that wherein it has been held that unless the complainant satisfied the authority that the discharge voucher was obtained by fraud, misrepresentation, undue influence, and coercive bargaining,
Before you
etc.
go to, madam, that is what I was telling you. Before you go to the judgment, look at the judgment. PLA, how it has dealt with. Now read paragraph 3, page 40. Paragraph 3 pile,
Again,
page 40. But
Yes, Your
exactly
Lordship.
the claim file of the applicant was processed and company decided to settle this claim at 9,000, 9 lakhs.
9 lakhs.
Say to Podam.
According to the respondent, the applicant accepted the settlement and submitted duly signed discharge voucher as well as a cancelled check.
Slowly, say part register, slowly podive. Do not register.
According to the respondent,
The applicant accepted the settlement.
Applicant accepted the settlement.
He signed discharge voucher as well as a cancelled
cancelled
check.
check for transfer of the settled amount and accordingly said amount transferred. Maintain it is further submitted that since the
System.
applicant received the amount
Hmm.
without protest and objection.
Hard learned counsel for the petitioner. The petitioner is the insurance company. Ourselves, by filing the writ application, the award dated 18/9/2025, passed in PLA case number 114/2019 by the Permanent Lok Adalat, Public Utility Services, bracket closed, Khurda at Bhubaneswar. The case number of our data dakili. I guess 18/9/25. The grounds of challenge is that the petitioner before the applicant before the PLA is owner of a business, hatchery business. With a policy number, that is paragraph 2 paragraph 2, page 39. 39. Policy number dash for the period from 4/5/2018 to 3/5/2019. Then covering the risk to neki from day 1 to day 21, like covering the risk in respect of the building, plant, machinery, packing material, plastic crates, gunny bags, cardboard, paper, stock of eggs from day 1 to day 21. Stop. Thereafter, the cyclone Fani on 3/5/2019 damaged the building, plant, machinery, packing material, stock in process, eggs. The applicant informed the insurer company, the insurance company. The damage was surveyed by the accredited, approved surveyor.
Accrued, sir.
Yes.
Accrued.
Accrued to hon. Accrued ortho pura alga.
Your Lordship, I got you deputed licensed surveyor, namely so and so.
Licensed surveyor.
Licensed, deputed licensed surveyor.
The damage was surveyed by the licensed surveyor.
Namely NK
The
Sahoo.
amount of loss was assessed at rupees 9, kete gode kothile?
9.03.014.
Put lecture 9.
Your Lordship, say paragraph.
9,03,
0.014.
1014. ଗୋଟେ କାଗଜରେ ଲେଖି ଦିଅ
9,03,014, Your Lordship. Page number 40.
ପାରା 3 ରେ ଅଛି
Agya.
9,03,014.
Agya.
In the survey report in the report of the surveyor dated 13/6/19, the claim was processed retaining an amount of rupees 3,000. Kete ko apan retain kale?
3,014 in the heading
14
for policy reinstatement.
for policy reinstatement.
Reinstatement policy by
Policy reinstatement.
3.014 minus correct.
9 lakh was paid to the insured. He signed the discharge voucher dated 10/7/2019. ठीक अछि तो annex 4 रे.
I guess.
When I am dictating, you must check the facts.
Yes.
10/7/2019. The said discharge voucher is also annexed to the present writ application and was produced before the PLA. Perusal of the PLA, the learned counsel relies on the decision of the Honorable Court as option.
Your Lordship, beg your pardon, mo ani ni.
Body nan.
Nahi, ani ni sir.
United India Insurance versus
Ajmer Singh.
Ajmer
Singh. Again.
United India Insurance versus Ajmer Singh.
Ajmer Singh, Cotton and General Mills.
Ajmer or Ajmer Singh?
AJMER. Ajmer.
Ajmer
Singh.
तापर सिंह भी अच्छी.
Again.
ठीक अछि.
Comma, Cotton and General Mills.
Nice, better than that. We are students of law. No, leave it there. We continue to be students of law. That's a very apt quotation by the great Nariman. Once a student of law, always a student of law. The learned counsel for the insurance company relies on the decision of the Honorable Apex Court in Ajmer Singh actually. Ajmer Singh Cotton, and you are right. Ajmer Singh Cotton and General Mills.
I beg your pardon, Your Lordship. Total case like United India Insurance versus
United India Insurance versus Ajmer Singh. AR 99 Supreme Court 3027. To support her contention, Sidre kon koile?
held that unless the complainant satisfy the authority that the discharge
Which contention that unless
the complainant satisfy
the claimant satisfy the authority that the said discharge certificate
was obtained by fraud, mischievous
the discharge certificate was result of the discharge certificate is
discharge voucher, Your Lordship.
vitiated due to factors such as force, fraud, duress. The discharge certificate cannot be set aside. No, the discharge certificate cannot be ignored. Stop.
I beg your pardon, Your Lordship.
आपको submission टा modify करिया पड़ेगा.
Okay.
There I have a contribution. Whenever a submission is made, I try to take care of the words. In the perusal of the judgment indicates that the learned PLA have noted the payment of rupees 9 lakh.
Can I interfere, Your Lordship?
No, just 1 second.
Okay.
Have noted the payment of 9 lakhs and also noted the discharge certificate. however, have not given any finding how the PLA could proceed ignoring the payment and discharge certificate, ignoring the settlement of the insurance amount and the discharge certificate. Yes, full.
Your Lordship, जो contention टा अपन कहले तार गोटे part खाली कहूची he is जो अपन जो कहले coercive external bargaining सब गुड़ाक तापर he is stopped from filing the complaint claiming additional payment from the insurance company in respect of its claim. It is second contention.
तो आपण से आसिला परे
जो contention of the Ajmer
is enough for you to argue that they have simple point है जे the court has ignored it. May not be maybe a complex point also.
he is also stopped from further payment.
सेटा से आसुंतु. Whether estoppel can operate or not, that has to be seen. Then आपनकर claim टा थिला 26 लाख टंका.
Again.
Usually insurance company कहंती जे insurance करिबा महापुण्य claim करिबा महापाप. So very extreme. Even I have asked in local adalat that whether repudiating claims gives promotion. आपण 26 लाख को 9 लाख कर देले तापर कहले estoppel.
Your Lordship will rely on
So
the
you must understand that when you over argue a matter, this will be the questions asked to you.
Your Lordship come
26 लाख टंका जदि ताकर आपण जेति की बिल्डिंग लैंड बिल्डिंग जेति से लेखा भी है 26 लाख टंका इज नॉट ए एक्सॉर्बिटेंट अमाउंट बुझपारछन आपण जहा इंश्योर करथिले कोन इंश्योर करथिले Honda was the last part.
Your Lordship,
Arambaric building ru everything entire stock livestock everything
we have detailed calculation of the survey report.
एटा हबो आज्ञा आप इंश्योरेंस क्लेम करिया महापाप आपनकर स्टैंडर्ड है ये क्लेम कला से पापी आपण ताको एते तुच्छ कर दियति कोर्ट रे एनो सेति पई मे बी आई डोंट नो 9 लाख 26 केमती हे गला आपण फाइनल नै गले सेटलमेंट
Your Lordship
पढिबे
calculate.
आपण ओडे डिसीजन अछि whether fundamental right can be waived or not. तो जनकर 26 लाख टका क्लेम हैला आपण ताको 9 लाख टका कहले से 9 लाख टका नेला माने आ तार गति नै सरी होला ते बर्तन केते दैचंती PLA
Your Lordship 9 lakhs पर further 8,15,960.
देखो तथापि PLA के 17 देना है 26 लाख टका की करथिला
से माने claim करथिले.
क्लेम कर आपनकर रिपोर्ट आसिला सी भी आपनकर देखिबे जे रिपोर्ट तयारी करंती तांको सब जिंस छोटो लागे कम लागे सेटा भी गोटे वेरी सिग्निफिकेंट एस्पेक्ट ऑफ इंश्योरेंस जूरिस्प्रूडेंस a contract of insurance is what their doctrine of utmost good faith is applied but whether doctrine of utmost that is uberima fide is the yeah. Don't speak unless you are asked. And then please don't say, sorry. You have to control your temptation also. So, but that doctrine of utmost good faith also applies to the insurance company also.
So
आपण जेतोळे क्लेम हबो आरंभ करी आपण कहबे जे से कुकुडा को घुमा रोग होइतिला से जणे नथिले ताकर पांचटा डिजीज थिला से जणे नथिले
So we completely rely on the documents, Your Lordship. That's why.
it is much more the less spoken is better to a certain extent like things work no doubt but the way you handle things is very unusual. सेटा आपण जदि मु एबे लिखि देबी स्टॉप आई विल अप्लाई I will be doing the same mistake or worse mistake than the PLA. कौन देखिए issue notice along with this order to the opposite party. This court, while issuing notice, takes note of the case, the law laid down by the Honorable Apex Court in State of Punjab versus so and so. And prima facie, it is indicated that the appellants the petitioner's insurance company have a case. State of Punjab versus Jalorsi. State of Punjab versus Jalorsi. Subsequent road affidavits. Yes. Yes. No, requisite for issuance of notice by speed post with registration and proof of delivery shall be filed. So, option to reply another behavior, sir. तो देखिए जो देखिए नोटिस टा जो आपण नोटिस पाइले नी जाइक पाइ छथि तो अतल नोटिस टा आपण से फाइल संगर देबे फाइल टाणी छथि हां फाइल शall be filed within 5 working days. In 5 working days आपण आईए फाइल करि ना
ये लॉशिप मो एक्चुअली प्रॉब्लम है मो आईए टा फाइल
in
करनी
the interim it is directed that आईए टा माने आजि फाइल करिवे आस परिबो
आसी परिवन लॉशिप
in the interim it is directed na there is no urgency for
अर्जेंसी अछि
okay.
लॉशिप
In the interim it is directed that the
डेटा फाइल कर पानी है लॉशिप
the award dated 18/9/2025 passed in PLA case number 114/2019 shall not be given effect to till the next date of hearing. आपण त्या भीतर फाइल कर दियंता
आगे
एक्सटेंशन पे
आई मे बी पार्डन योर लॉशिप मोर इंस्ट्रक्शन अछि जे एग्जीक्यूशन केस ऑलरेडी प्रोसीड करूची तो
shall remain stay. Our stay ला पर एग्जीक्यूशन कोन हो
आगे आगे ये लॉशिप मेरे डेट टा जे मो रीओपनिंग डे दिन कि
रीओपनिंग डेट तो मु कहि दिले आपण कहि ना सॉरी आई हैव नॉट only the returnable date be fixed to
आगे
केबे रिओ आपण डेट करंतु आगे पोस्टिंग डेट केबे
6
नहीं आपण पोस्टिंग केबे करछंती 6 ने ता परे कोन आपण 6-7 के करले ता आफ्टर नोटिस the matter shall be listed for orders. The returnable date be fixed to 20/7. The matter shall be listed for orders in the week commencing 27/7. आपण अर्ली चाहउचंती
सर जून मास
आपण तो स्टे हे गला आपण उल्टा करछंती जो स्टे हे जाय गोटे पत्थर तबराणी मडे दे really so that the court will require a excavator. That was my answer to Mr. Mohanty. I answered you. Excavator নহলে से केस उठी परिबो. Mr. Mohanty कहतले जे काई स्टे करनांती he can ask. तो हमने ताले ठीक अछि आपण ता भीतर फाइल कर देबे
आगे
yes liberty to mention
oblige your lordship
yes but good that you are reading, you are thinking about the case and you have a case law directly on the point. Instead of making a general speech, you are saying that this discharge certificate cannot be ignored if it is vitiated. On estoppel overstate chayegala, ठीक अछि, but that point has to be noted by the court. The party is stopped from raising again a claim. That is your point.
आगे
But they may have an answer. जे आपनकर 26,000 को 9,000 कर देले तापरे आउ कहले गला आपण पापी तो सेटा yes.
It has not been.
Actually, this side, there is a different view regarding insurance law because we are monitoring the entire state. आपण कोठी केते सेटल करूछथि those information we are having. At least I have. And कोठी आपण मना करूछथि. So now, because since you are practicing in this branch, that's a very interesting aspect. In certain cases, I find not here because I try to understand. Kind of, बहुत चेष्टा करूँ जो अपन करो लोकल अदालत रे अचीव करे हैं. बहुत चेष्टा करा है. We are consulting, we are directly monitoring. I monitor my districts where I am the portfolio judge. There I find जे अपन को 10 लाख जगह रे 4 लाख कहले भी अपन राजी होना. तो जोठी आपण बिल्कुल दबा का ना आपण 5 लाख 6 लाख दउछ 10 लाख दउछ. That is also happening. So I mean at times sitting here we have to be very circumspect. We cannot say certain things, but these things are also there. And this is the extreme case. जे आपनकर से बिल्कुल इग्नोर कर देले 9 लाख टका रे आपण देले सर्टिफिकेट हैला सब हैला पण ता डिस्चार्ज सर्टिफिकेट हैला बट से किछ डील कले. You may be right, but there is a broader picture to this.
आगे
many times I find the MACT presiding judge, they say that even they are not, in fact, they are worried. They are semane apanakara claimant को बाध्य କରୁଛନ୍ତି ଯେ ତମେ settle କର 6 ଲକ୍ଷ ଟଙ୍କା ଜାଗାରେ 4 ଲକ୍ଷ ଟଙ୍କା ତାକୁ ରାଜି କରୁଛନ୍ତି ତାପରେ ବି ଆପଣ ମନା କରୁଛନ୍ତି ତାପରେ କରାଯିବ କଣ
ସେଇଟା ଆମେ ତ
how you can so ସେଥିପାଇଁ in fact I asked this question ବହୁତ ବିଶେଷ କେସେସ୍ ଆସୁନି କିନ୍ତୁ ଲୋକ ଯେତେବେଳେ କରୁଥିଲେ ମେ ବି ଆପଣଙ୍କର ଇନସେଣ୍ଟିଭ ଯେତେ କମ କ୍ଲେମ ହବ ସେତେ ଭଲ yes next please
obliged to lordship.
14. You're also on our part where the local general challenge.
ground hoche se party nathile na notice ei nathila
Nahi, without notice, but their signatures have been opted. Fraud and misrepresentation, that is the only
fraud usually I am not observing but obviously you can say that you are not a party. Mr. Dwarika Prasad Mahanti for the petitioner, opposite party blank, the petitioner invoking the articles 226 and 227 of the Constitution of India. Petitioners plural. Challenge the order passed under section 20 of the Legal Services Authorities Act 1987. By the by the civil judge into bracket senior division bracket closed Noyagada in CS number 26 of 2023 by award dated 14/9/2024 decree भी ହେଇଯାଇଛି so judgment and decree the same date हवा कथा as per CPC अलगा date केमती होଉଛି
नहीं decree ta subsequently
but CPC ର provision देखुଛି जे the decree shall bear the date of the judgment very
within
clear
15 days from the date of the
this was asked by Justice Sinha actually because he is a prolific practitioner so I also could not answer that properly
within 15 days from the date of the judge
and the consequential decree stop
maybe on the
it
same
is submitted that the petitioners are necessary and proper parties who were not arrayed as parties in the CS
they were added
the petitioners being proper and necessary parties were arrayed as parties in the CS however their consent produced before the learned civil judge senior division is vitiated by
fraud
and misrepresentation. In continued opinion of this court, applying the principles laid in State of Punjab versus Jalor Singh, this is a case where notice is to be issued to the opposite party. Para. Issue notice to the opposite party along with this order. Requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within
5 working days.
5 working days. Returnable date be fixed to 13/7/2026. Three jana party achanti
Around 4 to 5.
Says
7
14/7/2026.
7 parties.
The matter shall be listed for orders in the week commencing 20/7/2026. IA 3490 of 2026 issue notice as a hard learned counsel for the petitioner. He reiterates his sufficiency as noted above. Issue notice as above. Accept one set of process fee as well as postal requisites. The returnable date as well as the next date of listing shall be as directed above. In the interim, it is directed that award ଆପଣଙ୍କ share part ଟା କିଛି କହିପାରିବେ ମତେ
ପୁରା relinquish କରି ଦେଇଛନ୍ତି
ପୁରାଟା
ହଁ ଦିଟା
it is a relinquishment deed ଆପଣଙ୍କ ନାଁରେ ହେଇଗଲା
compromise କରିକିରି we have supposed to have been relinquished our claim
entire thing
in favor of another
partly ଏଟା କରି ହବନି ତାର ଠିକ ଅଛି ତ order na judgment of 8/4/24 na କଣ
award
the award dated 8/4/24 date ଟା ମୁଁ ଠିକ କହୁଛି ନା 14/9/24 14/9/24 passed in CS number 26 of 2023 by the learned civil judge into bracket senior division Noyagada shall remain stayed until further orders. liberty to mention. Yes, next.
15.
Mr.
Item 15 notes.
Yes.
The petitioner has come.
No, Mr. Acharya.
Yes, ma'am.
Mr. D. Acharya for the petitioner. Yes, please.
Yes. The petitioner has come with an innocuous prayer before your lordships
Expedite.
for expediting the divorce proceedings, my lords. In CP number
Supreme
one.
Court's Constitution bench judgment is not innocuous.
No, my lords. Why I say so is.
So that order I will pass and I will say that they will cooperate.
Yes, my lords. Because the opposite party is not appearing, nor the family court is
Sir,
taking.
you file that application.
Yes, ma'am.
Whenever the opposite party, the respondent is not appearing, you have to file that CPC petition.
Ma'am.
You will ask the court to pass a order.
My lords.
Then you can come here.
Ma'am.
But anyway, and it happened expeditious disposal judgment. This first time.
Deeply obliged.
Yes, please. Yes, next, please.
16.
16 आज तो समय आपन बाहर रे गोटे बेले बजे फंक्शन ताले आपन 16 टा पोस्टिंग कर दियो पास ओवर करंतु
20 item.
जस्ट वन
Item 16.
अछंती सॉरी मिस्टर रत्नाकर समंत सिंगर फॉर द पिटिशनर यस प्लीज
Short prayer Miller for expeditious disposal of the
same expeditious after you must read Justice Oak's judgment. He says after the Constitution bench judgment, what the High Court should not do is doing every day. This kind of comment, so don't. So
I am for the petitioner.
Cooperation. That part I will say. Unnecessary adjournment, cooperation. Those are innocuous. As Mr. Acharya was saying, seta innocuous hai jibo thik achi.
Another party, wife has filed the WS and she has admitted that she has no objection for any.
But sir, trial re mate bharti karantu. You are tempting me to enter into trial. Ki कहले नि मोर evidence देबी जड़े कहले जे मु सळा को आनिबी आ जने कहछन जे मो हस्बैंड और बेस्ट फ्रेंड को आनिबी से सब रे मते कहंतु सेठी आपण कहंतु जा असुविधा बेटी आसंतु मु हटा ट्रायल करबा आरंभ करबी
Divorce हेलन तो सेठी
divorce रे सर जदी
both party are agreed for divorce.
The problem is the comment is very sharp by the Supreme Court that whoever is coming to a constitutional court is not a privileged litigant. That is the point they are making and it's correct. बहुत लोग यहाँ अपेक्षा करते हैं सेठी. Yes, disposed of, but that part will be there.
Yes.
It will say same early disposal judgment. It is Mr. Ratnakar Samant 16. 17 Mr. Mahapatra.
Yeah, on behalf of the address.
Yes, please.
In this
You are
case,
Mr. Sahoo, SC Sahoo.
SK Nath.
Mr. SK Nath.
Again.
Mr. SK Nath on behalf of PK Mahapatra for the petitioner. Kuhantu sir.
Petition was filed before this permanent proposal term. And it's the two regarding demanding excess claim and settle the issue. Excess claim amount.
Excess claim में ही परिवनी. Appeal रे हवा. अरे प्लीज मु बुझी परनु मे बी आपण मते क्लियर करंतु आपण पीएल रे ओरिजिनल क्लेम थिला ना एक्सेस क्लेम से कोइ पई कहले
Excess claim पे
एक्सेस क्लेम केंति आपण एक्सेप्ट करथिले अर्लियर धरंतु लाइक 9 लाख 26 लाख थिला यू टेक दैट एग्जांपल ऑफ पोल्ट्री फार्म 26 लाख थिला 9 लाख रे से सेटल कले पीएल को गले पीएल ताकू कर देले 8 लाख दैट इज वन केस बट आपण केस रे कोन हला
जते ऑर्डर कले आनेसर 5 रे
नहीं इनिशियल केते थिला एक्सेस क्लेम जो कहउछन्ती ओरिजिनल क्लेम ता केते थिला आवार्डेड अमाउंट केते थिला
मला टोटल आउटस्टैंडिंग लोन थिला टोटल 44 लाख
एटा कोन एटा ओटे बैंकिंग ता
बैंक ट्रक
लोन
यस
तो सरफेस रे जुरिसडिक्शन नहीं
रपर
अपन अर्जन कर दियंतु
ना लोकल तो ऑर्डर चैलेंज
लोक तो लाइन सब भल लागे करिया पे मते जेंति कोजन ट्रायल करंतु मते भल लागुनी कि 227 रा मोर एनॉर्मस पावर अछि एटा इलीगल ऑर्डर
नोटिस दाउ
नहीं इलीगल नोटिस
इलीगल
आपण आगे स्पेशल मैटर टा को कर देले लोक अदालत रे देयर इज अ कंप्लीट अगेन लोक अदालत रे द सुप्रीम कोर्ट हैज लिटरली scolded हाई कोर्ट टू इंटरफियर और ट्रक लोन सेटल करी तापर कोन हला फेरे
नहीं से 2 लाख टोटल तार अमाउंट आउटस्टैंडिंग वर्तमान ताको हिसाब रे 2-3 लाख अछि किंतु से डिमांड करजन 14 लाख सब दे बैंक
नाउ आई अंडरस्टैंड आपण जो कोजन एक्सेस मु इंश्योरेंस बुझी कहउतली ଆପଣଙ୍କର 14 ଲକ୍ଷ ଟାକୁ ସେ 2 ଲକ୍ଷ କରିଦେଲେ
ନାଇଁ
PLA
ସେଇ ଲୋକଙ୍କର
ନା ଲୋକ ଦେଲେ ଡିସମିସ୍ କରିଦେଲେ
ନାଇଁ ଡିସମିସ୍ କରିନାହାନ୍ତି
ଆଉ?
ସେ ଡିମାଣ୍ଡ ଡାଇରେକ୍ଟ କରିଛି ଟୁ ପେ ଏଭ୍ରି ମନ୍ଥ ଇନଷ୍ଟଲମେଣ୍ଟ ଡ୍ୟୁସ୍
ତ ଆପଣ ଫେଭରରେ ଅଛି
£1,00,000 ଦିଅ
ଆପଣ ବର୍ତ୍ତମାନ ଆପଣ ଯୋଉ ବ୍ରାଞ୍ଚ ରେ ବସିଛନ୍ତି ତାକୁ ଚପ ଅପ୍ ନକରି ଗୋଟେ
ନାଇଁ
ହ୍ୟାକ୍ ଅଟୋମେଟେଡ୍ ସହ ଲଗେଇଛନ୍ତି ତା ଦେହରେ
ପୁରା ସେଟେଲ କରିଦେଲେ ଲୋକ
ବର୍ତ୍ତମାନ ସେଇଠି ଆସିବେ ସେ କହିବେ ଆଜ୍ଞା ଇଲିଗାଲ ଅର୍ଡର
ନାଇଁ petition is ready to deposit all the outstanding at one time.
ରେଡିନେସ୍ ତ ଆଜ୍ଞା ସମସ୍ତେ ଅଛନ୍ତି ସ୍ପେଶାଲି ହଜବାଣ୍ଡସ୍ ଆର୍ ଭେରି ରେଡି ଟୁ ଡିପୋଜିଟ୍ ଇନ୍ ୱାନ୍
ନାଇଁ ହଜବାଣ୍ଡ କେସ୍ ଏଗୁଡ଼ା ନୁହଁ
ତେଣୁ ସେଇଟା ତ ମୁଁ ରେଡି ଶୁଣିକିରି ମୋର ଗଲାଣି ପୁରା ମାନେ ଇଏ ଆପଣ ଏଇ କେସରେ ବିଲକୁଲ ଇଏ କରନ୍ତୁନି ମୁଁ ଆପଣଙ୍କର ଯଦି ସେ କରିଛନ୍ତି ଇନଷ୍ଟଲମେଣ୍ଟ ୟୁ ଫାଇଲ୍ ଇନଷ୍ଟଲମେଣ୍ଟ ହ୍ୱାଟ ଏଭର ଆପଣ ତ କ୍ୱାଣ୍ଟମ ଏଠି ଚ୍ୟାଲେଞ୍ଜ କଲେନି ଇଟ୍ସ ଏ ନୋଭେଲ ଜୁରିସଡିକ୍ସନ ଆପଣ ପିଏଲଏ ଯିବା କଥା ନୁହଁ ପିଏଲଏ ଗଲେ ସେ କହିଲେ ଇନଷ୍ଟଲମେଣ୍ଟରେ କେତେ ଟଙ୍କା କଲେ ଆପଣ ଡିମାଣ୍ଡ କେତେ ଥିଲା
ଡିମାଣ୍ଡ £1,00,000 ଏରିୟର ଦେଇଛନ୍ତି 20,000 ଏଭ୍ରି ମନ୍ଥ
ଟୋଟାଲ ଡିମାଣ୍ଡ କେତେ ଥିଲା ବ୍ୟାଙ୍କର
ବ୍ୟାଙ୍କର ଥିଲା
ଠିକ ଅଛି ଆର୍ଜନ କରିଦିଅନ୍ତୁ ସମୟ ବି ହବନି
13,60,000 ଥିଲେ
13 ଲକ୍ଷ ଟାକୁ କରିଦେଲେ କେତେ ସେ
ସେ କରିନାହାନ୍ତି ତାଙ୍କ ହିସାବରେ ସେ ଆଉ 2-3 ଲକ୍ଷ ଦେବାର ଥିଲା ମାତ୍ର
ଆରେ ପିଏଲଏ କେତେ ଟଙ୍କା କଲେ 13 ଲକ୍ଷ ଟାକୁ
£1,00,000 ଦେଇଛନ୍ତି ଏରିୟର ଦେବା ପାଇଁ ପ୍ଲସ୍ ଏଭ୍ରି ମନ୍ଥ 20,000 ଦେବା ପାଇଁ ଆଉ
ସେଇ 20,000 ଟଙ୍କା ଟା ଇନଷ୍ଟଲମେଣ୍ଟ କରିଦେଲେ
ହଁ
ତ ରିଟ୍ ଟୁ ବି ଅଧିକା ହେଇଗଲା ରିଟ୍ ରେ ସେ ଡାଇରେକ୍ସନ ବି କମ ହୁଏ ମାନେ ସବୁ କୋର୍ଟ ଦଉନାହାନ୍ତି ବହୁତ କୋର୍ଟ କହିବେ ଯେ ତାପରେ ଯଦି ବି ଦେବେ failure to payment of one single installment shall entail forfeiture of the recall of the entire loan amount ସେ ଅର୍ଡର କରି ଦିଅନ୍ତି କାହିଁକି ନା that has been stringently observed by Supreme Court ସେ ଯାହା ଅର୍ଡର ହେଇଛି ଭଲ ହେଇଛି ଅର୍ଡର anyway adjourn the matter shall be listed for as paid for the matter shall be listed for fresh admission in the week commencing Odisha ସେ actually ଏବେ ଆପଣଙ୍କର ଗୋଟେ ବେଳେ ବାର ଇନଭିଟେସନ ଟା ଅଛି so ଏଠି 1:30 ଅଛି so I will continue at 2 I'll try to come ଆପଣଙ୍କ ମ୍ୟାଟର ଟା ଦିଟା ବେଳେ ନେଲେ ହବ ମିଷ୍ଟର ତ୍ରିପାଠୀ କଣ ତାଙ୍କର କଣ କରିହବ କପି ଆପଣ ଇନଷ୍ଟ୍ରକ୍ସନ ନେବେ ଠିକ ଅଛି ଦିଟା ବେଳେ ପାସ୍ ଅପ୍ ଟୁ ଆଟଲିଷ୍ଟ 22 ତ ମୁଁ ହଉଛି ପହଞ୍ଚିଯିବି ବୋଲି ଆପଣଙ୍କର 23 20 ହଁ ଠିକ ଅଛି ଆଟଲିଷ୍ଟ ଫ୍ରେଶ ଆଡମିସନ ଆଇ ୱିଲ୍ କଭର ଫୁଲ କୋର୍ଟ ଅଛି କେତେ 2:45 ଦିଟା ବେଳେ ଅଛି 3 o'clock so let us be quick next call କରନ୍ତୁ sir sorry 500 କରିଦେଲେ କି 500 ସ୍ଟେସ ଆରମ୍ଭ କର 18 so
This is petitioners challenge the compromise decree passed in local adalat.
yes ground sir ground
Fraud. They never appeared in the suit. The petition never appeared in the suit, but on their false signature, suit was filed.
the petitioner before this court challenges the order by passed into local adalat
Page
26
Page 34.
21
No, 11, 12, 21. 11, 12, 21. You also page 34 here.
ভুল ফেল করছি না I have opened another file
Page 34 here. A petition suit was filed. And final decree was filed in the local adult.
The order in CS number 133 of 2021 passed into local adult, as well as the order
Final
dated 20 order state pays to the ठीक है
34.
34 ଆପଣ 21 ମସିହାର order ଟା ଚ୍ୟାଲେଞ୍ଜ କରୁଛନ୍ତି
Yes.
order dated 25/11/2021 passed by the civil judge junior division Nimapada in Lok Adalat in CS number so and so. They submitted that the present petitioner was a necessary and proper party.
3 petitioners.
The present petitioners are necessary, should have been the necessary and proper party.
No, they were made parties.
Okay, though the present petitioners were made parties, but they have not appeared.
They have never appeared,
They have
never.
not appeared or agreed for any settlement. However, the settlement before the national level Lok Adalat or the national Lok Adalat on 11/12/2021 was obtained behind their back. Stop. Issue notice on the question of admission to the opposite parties.
It was 1, 2 only.
Why, sir?
It was
1 and 2. 1 and
yes,
2
3, 4 or not necessary.
Okay. By speed post with registration and proof of delivery. Requisites to be filed within 5 working days. Returnable date be fixed to 8 July 2026. The matter shall be listed for orders in the week commencing 13 July 2026. As an interim measure, interim period which he
No, because no execution case has
execution
been filed.
okay, good. Liberty to match.
19.
Mr. Pradipta Verma for the petitioner. Yes.
Lord, I have got a very short submission, madam. Lord, I am, as per the order of the Honorable the Law and Family Court, I am keeping on paying the interim maintenance of 18,000 since November 2017. But suddenly, my lord, in 21 April 2026, my lord, the Law and Court passed the order increasing the maintenance for the child from 9,000 to 60,000, my lord. My lord, the boy is only 12-year-old. He is studying in class 6, my lord.
But you are continuing to pay the current.
I am continuing, my lord.
So where you have stated in your application?
My lord.
ଆପଣ ଦଉଛନ୍ତି ଯୋଉଟା amount ଟା continue.
Page 9, my lord. My lord, para 6, my lord. Submitted that 18,000 at the rate of 18,000, my lord.
Sorry, ଆଉ ଥରେ କହିଲେ. Who pays the paragraph?
Page 9, para 6, my lord. Roman 6. Till that, my lord, I have paid 18 lakhs, my lord.
The petitioner husband in the marriage
My lord,
and father of the ଆପଣ ଖାଲି କଣ child ପାଇଁ କହୁଛନ୍ତି?
no, child ପାଇଁ wife ପାଇଁ ବି wife ର ଏବେ 2 ଲକ୍ଷ
The
ଟଙ୍କା
husband in the marriage and ଆପଣ ଯେହେତୁ ସହରରେ ଅଛନ୍ତି ବର୍ତ୍ତମାନ $100 ହେଇଗଲାଣି actually 100 ଟଙ୍କା ହେଇଗଲା
$114 ହିସାବରେ ମୁଁ ହିସାବ କରିଛି ମାନେ ଏଟା ହଉଛି ବ୍ରିଟିଶ ପାଉଣ୍ଡ
114 ଟଙ୍କା ବର୍ତ୍ତମାନ
114 ଟଙ୍କା ତା ଦେହରେ 2,88,000 ହଉଛି ଆଜ ଆଡମିଟେଡ ୱାଇଫ ର 2,12,000 ମାନେ ମୁଁ ଡକ୍ୟୁମେଣ୍ଟ ବି ସବମିଟ କରିଛି ଏଟା ୱାଇଫ ର ଡକ୍ୟୁମେଣ୍ଟ
ଯଦି ମାନେ ଆପଣଙ୍କ ଫାଦର ଆଉ ହଜବେଣ୍ଡ ଚାକିରି ରହିବେ they earn in UK pounds so the child and the mother will be having that amount of maintenance actually. But anyway, since you are saying that you are paying, they will take notice. The petitioner is the husband of the opposite party and father of the minor child born from the wedlock. He has approached this court by filing the petition. Order dated 21/4/2026. ଆପଣ ଯୋଉ amount ଟା ହେଇଛି ବର୍ତ୍ତମାନ ସେଟା ସେଇ appearance ପର୍ଯ୍ୟନ୍ତ ଦିଅନ୍ତୁ. There is a purpose. ଆପଣଙ୍କର ବର୍ତ୍ତମାନ enhance amount ଟା କେବେଠୁ ଦେଇଛନ୍ତି?
ମାନେ 25/4/2024 ରୁ ଦେଇଛନ୍ତି ସେଟା ଆଜି
back date ରେ
ଆଚ୍ଛା
ଠିକ ଅଛି ତାହେଲେ ଅସୁବିଧା ହବ 21/4/2026 passed by the Lorded Judge Family Court to Bhubaneswar in civil CP number 76 of 2017 allowing the petition dated 25/6/2024 enhancing the pendant light maintenance directed earlier to be paid in an application under section 24 of the Hindu Marriage Act. During pendency of the CP kiye file kale?
ମୁଁ ଫାଇଲ କରିଛି।
During pendency of the CP filed by the petitioner seeking dissolution of marriage and grant of decree of divorce. Stop. At paragraph Roman 6 paragraph
VI page 9
para 4 VI at page 9 of the writ application, the petitioner has stated that he is continuously paying the amount of rupees 18,000 per month. Since 27/11/2017 and will shall continue to ଆପଣ 18,000 ଟା କେତେ ହେଇଯାଇଛି ଏବେ?
18,000 টাକୁ ଦି ଭାଗରେ ଗୋଟେ ହଉଛି 9,000 ଏବେ 69 ହେଇଯାଇଛି 69
ଟୋଟାଲ ଟା 69 ହେଇଯାଇଛି।
ମାଇଲ ପୁଅ ପାଇଁ 60 କରିଦେଲେ ୱାଇଫ ର 9,000 କଟ।
18,000 ଆପଣ ଇଣ୍ଡିଆନ ଗ୍ରୁପରେ ଦଉଥିଲେ।
ମାଇଲ କଣ୍ଟିନ୍ୟୁଅସ୍ ମୁଁ ଦଉଛି।
ଆପଣ ଏବେ କେତେ ବଢିବାକୁ ଚାହୁଁଛନ୍ତି?
ସମ୍ ଆମାଉଣ୍ଟ ମାଇଲ
ସମ୍ କେମିତି ହବ? ଆପଣ ଦେବେନି ତ ମୁଁ ଦେବେନି।
ଇଭେନ ମାଇଲ ଡବଲ ବି ଯଦି
40,000
9,000 ଟଙ୍କା ଯଦି 18,000 ବି ହେଇଯିବ 20,000 ପୁଅ ପାଇଁ ୱାଇଫ ପାଇଁ ଯଦି ବି କଣ୍ଟିନ୍ୟୁ କରିଦେ
20,000 ଲାଗିଲେ ଆପଣ ପାଇଁ ପିନଟ୍ସ।
ମାଇଲ ଇଟ ଇଜ ନଟ୍ ଏ ଫ୍ୟାକ୍ଟ ମାଇଲ କଣ ହଜୁର ମୁଁ ଖାଲି ଗୋଟେ ସବିସନ ମାଇଲ ସେ ତା ନାଁରେ ଗୋଟେ କେସ୍ କ୍ରିମିନାଲ କେସ୍ କରିଦେଇଛନ୍ତି ସେଥିପାଇଁ ସେ ଚେଞ୍ଜ କରିପାରୁନାହାନ୍ତି କମ୍ପାନୀ ସେ ଅଧିକା ବି ପାଆନ୍ତେ ସେଟା ମୁଁ ଲେଖିଛି ଏଠି ସେ କମ୍ପାନୀ ଯୋଉ ପ୍ରୋକ୍ଟର ଆଣ୍ଡ ଗ୍ୟାମ୍ବଲ
ସେଇଟା ଆଜ୍ଞା ଭୁଲ କହୁଛନ୍ତି ସେ ବର୍ତ୍ତମାନ କୌଣସି କମ୍ପାନୀ ପୃଥିବୀର ପଇସା ଦଉନାହାନ୍ତି ସେଟା ଆପଣଙ୍କୁ ଗୋଟେ ସେ ବଢିଆ ପଟି ପଢେଇଛନ୍ତି
ନା ମୁଁ
ଆଜ୍ଞା ଏମିତିଆ ଲୋକ ଯେ ତାଙ୍କର କମ୍ପାନୀ ଚେଞ୍ଜ କଲେ ବଢିଯିବ ସେ ପାଇଯିବେ ବର୍ତ୍ତମାନ 114 ବର୍ତ୍ତମାନ କେତେ ପାଉଣ୍ଡ ଷ୍ଟର୍ଲିଂ ପାଉଛନ୍ତି
ମାଇଲ 41,000 ପାଉଣ୍ଡ ମାଇଲ
41,000 ପାଉଛନ୍ତି ସୋ ଆପଣଙ୍କର
ମାନେ ଟ୍ୟାକ୍ସ ଡିଡକ୍ଟ
31,000 31 into 112 ଭାବନ୍ତୁ ଆପଣ ଟୋଟାଲ ଇନକମ୍ କେତେ
ବର୍ଷରେ ମାଇଲ ଗୋଟେ
ବର୍ଷରେ ହଁ ଆପଣ କେତେ ଇନକମ୍ ହେଲାଣି ଭାବନ୍ତୁ
ମୁଁ କ୍ୟାଲକୁଲେଟ ମୁଁ ଲେଖିଛି 2,88,000
you continue paying 30,000 ହେଲା
ମାଇଲ
ହେଲା actually the point is something different because the other side they are not appearing once the court issues notice unless there is some incentive they don't appear so then the case gets dragged on ଆପଣ କିଛି ବେନିଫିଟ ହବନି କଣ ଲେଖିବେ continues to pay rupees 18,000 from with effect from 27/11/2017 till date. It is submitted by the Lorded Counsel for the petitioner that the increase directed by the Lorded Judge Family Court is very steep as would be evident as the amount has been fixed at rupees now the amount has been fixed at
60,000 for the child and 9,000 for the wife
60,000 for the child and 9,000 for the wife coming to 69,000 from the date of application that is କେତେ 24 ଗୋଟେ ଯୋଉ ଉପର ଡାକିଥିଲି
25/6/2024
para issue notice along with this order to the opposite party requisites for issuance of notice be filed within 5 working days returnable date be fixed to 9 July 2024 the matter shall be decided on in the week commencing 20 July 2024 issued hard Lorded Counsel for the petitioner he reiterates his submissions as noted above issue notice as above so execution file ହେଇଛି
no mail ଏବେ ମାସେ ହେଲାଣି ହେଇଛି ମତେ ସେ
ଛାଡି ଦିଅ
ମାସେ ସେ ଦେଇଛନ୍ତି
ଆସନ୍ତୁ
ମାନେ ହଜୁର କଣ ହଉଛି ମାନେ ଲର୍ଡେଡ କୋର୍ଟ କହିଦେଇଛନ୍ତି
ବୁଝିବା ଦରକାର ଆପଣଙ୍କର ଏକ୍ଜିକ୍ୟୁସନ ନାହିଁ ସୋ ଆପଣଙ୍କର ଲିବର୍ଟି ଅଛି ପରେ ଯେତେବେଳେ ଏକ୍ଜିକ୍ୟୁସନ ଫାଇଲ ହେଲା ଆପଣ ଆସିପାରିବେ ହୁଏତ ତା ପୂର୍ବରୁ ସେ ଆସିକି ଆପିୟର କଲେ
ହଜୁର ଖାଲି ଗୋଟିଏ କଥା କହିବି ଆ ଭିତରେ 21/4 ଭିତରେ ସେମାନେ 3ଟା ଆପ୍ଲିକେସନ ଦେଇ ସାରିଲେଣି ଯେ ମୁଁ ଡିଫଲ୍ଟର ଅଛି ବୋଲି ସେମାନେ ଗୋଟେ ତା ନେକ୍ସଟ ଦିନ ଦେଲେ
ଠିକ ଦେଇଛନ୍ତି ତ ଆପଣ ଯଦି ଆପଣଙ୍କ ତାଙ୍କ ୱାଇଫର କାଉନସେଲ ହେଇଥାନ୍ତେ ଆପଣ 6ଟା ଦେଇଥାନ୍ତେ knowing your chamber ଆପଣ ହାଇପର ଆକ୍ଟିଭ ଆପଣ 6ଟା କି 10ଟା ଦେଇଥାନ୍ତେ ସୋ ଜଣେ ଯଦି କମ୍ପ୍ଲାଏ କରୁନି ସେ ପିଟିସନ ଦେଲେ କୋର୍ଟରେ ହାଉ କ୍ୟାନ୍ ଆଇ ଟେକ୍ ଏକ୍ସେପସନ ଟୁ ଦ୍ୟାଟ୍
ମତେ 30 ଦିନ ଦିଆ ହେଇଛି ଟାଇମ ମାନେ 21 ପର୍ଯ୍ୟନ୍ତ ଆଜି ପର୍ଯ୍ୟନ୍ତ ଟାଇମ ଥିଲା
ଯେ ଆପଣ ଡିପୋଜିଟ କରନ୍ତୁ ତାହେଲେ ଆଟଲିଷ୍ଟ କରେଣ୍ଟ ଆମାଉଣ୍ଟଟା ଆପଣ ଯଦି ତା ଚାହୁଁଛନ୍ତି ତାହେଲେ ଆପଣ 69,000 ଟଙ୍କା ଯୋଉ ଆଜିଠୁ ଦିଅନ୍ତୁ, କରେଣ୍ଟ ଦିଅନ୍ତୁ, ଏରିୟର ଛାଡି ଦିଅନ୍ତୁ। ଜଜମେଣ୍ଟ କେବେ ହେଲା?
ନା ମାଇ ଲର୍ଡ ଜଜମେଣ୍ଟ 21
ଶୁଣନ୍ତୁ, ଦ କୋର୍ଟ ହାଜ ଟୁ ବି ବାଲାନ୍ସ ଦ ଇକ୍ୱିଟିଜ। ଆପଣ ବ୍ଲାଙ୍କେଟ ଷ୍ଟେ ଚାହୁଁଛନ୍ତି, ବ୍ଲାଙ୍କେଟ ଷ୍ଟେ ଚାହିଁବା ପାଇଁ ଆଇ ହାଭ ଟୁ ସେଟ୍ ଆସାଇଡ୍ ଦ ଅର୍ଡର। I cannot set aside the order while issuing notice.
ଏଠି ଆଉ ଗୋଟେ ମୁଁ ହଜୁର ମୁଁ ହମ୍ବଲି ସବମିଟ କରିବି। ଫାଇନାଲ ଅର୍ଡର ପାଇଁ ଲାଗି ଯାଇଛି 17 ଜୁନ ପାଇଁ, 17 ଜୁନ ପାଇଁ, କାରଣ ଦିସ୍ ଅନରେବଲ କୋର୍ଟ ହାଜ ଗିଭେନ ଏ ଟାଇମ ଜଜମେଣ୍ଟ ପାଇଁ।
ଠିକ ଅଛି, ଆପଣଙ୍କର ଯଦି କିଛି ଅସୁବିଧା ହବ ଆପଣଙ୍କ lie over liberty to mention, but you want a order in farm lines. That is a difficult proposition.
मतलब टू सब्जेक्ट टू पेमेंट ऑफ सर्टेन अमाउंट मतलब मुझे यदि बैक डेट रो भी ओटा 20,000 के 30,000 व्हाटएवर
ना ଆପଣଙ୍କର ଇନକମ୍ ଆପଣଙ୍କର ବହୁତ ଆପଣଙ୍କର ସେ
ମୁଁ ଆସେଟ୍ ଲାୟବିଲିଟି ହଜୁର ଆଫିଡେଭିଟ ଦେଇଛି, ମୋର ଇନକମ୍ 2 ଲାख।
ଶୁଣନ୍ତୁ, ପ୍ରୋବ୍ଲେମ ହେଲା ଯେ ମୁଁ ତ ବର୍ତ୍ତମାନ ଟ୍ରାଏଲ କରୁନି ନା, ମୁଁ ଆପଣଙ୍କର ଆସେଟ୍ ଲାୟବିଲିଟି କେତେବେଳେ କନସିଡର କରିବି? ଲୋଅର କୋର୍ଟରେ ହେଲା ପରେ 24-25 ହେଲା ପରେ, ଏଇଟା ଗୋଟେ 24, ଏଇଟା 24 ଅର୍ଡର, ଦିସ୍ ୱିଲ୍ ମର୍ଜ ୱିଥ୍ ଦ 25 ଅର୍ଡର, ବୁଝିପାରିଲେ? ସେକ୍ସନ 25। ସୋ ସେକ୍ସନ 25 ଅର୍ଡରରେ ଯଦି 24 ରେ କରିଛନ୍ତି ଆପଣ, ସେକ୍ସନ 25 ରେ ଆପଣ ଇଭେନ୍ ଗେଟ୍ ଆଡଭାନ୍ଟେଜ ଅଲସୋ। କଣ ଅଲ୍ଟିମେଟଲି ଆୱାର୍ଡ ହବ, ଆପଣ ତାକୁ ଚ୍ୟାଲେଞ୍ଜ କରିବେ। ତାପରେ ଆପଣ ଲମ୍ପସମ୍ ଆମାଉଣ୍ଟ ତାହେଲେ ଦିଅନ୍ତୁ, 2 ଲକ୍ଷ ଟଙ୍କା ଦିଅନ୍ତୁ। ଆପଣ ଟୋଟାଲ ଡ୍ୟୁ କେତେ ହେଲାଣି?
मतलब 11 लाख 22
5 ଲକ୍ଷ ଟଙ୍କା ଦିଅନ୍ତୁ।
व्हाटएवर माय लॉर्ड
5 ଲକ୍ଷ ଡିପୋଜିଟ୍ କର। ପିଟିଶନର ଡିପୋଜିଟିଂ ₹5 lakhs।
माय लॉर्ड मेक
ऑर्डर
लिटिल बिट लेस।
ନା ଆଜ୍ଞା, ଜଣେ ଆସି କହୁଛନ୍ତି ଯେ ମୋର 11 ଲକ୍ଷ ଟଙ୍କା ବାକି, ମୋର ପଇସା ନାହିଁ। ଆପଣ ନନ୍ ରେସିଡେଣ୍ଟ ଇଣ୍ଡିଆନ୍, ବର୍ତ୍ତମାନ 114 ଟଙ୍କା ଲେଖାଏଁ ଆପଣଙ୍କର ଭ୍ୟାଲ୍ୟୁ ଆପଣଙ୍କର।
ଖର୍ଚ୍ଚ ବି ସେଠି ସେମିତି ହଉଛି ହଜୁର।
ନାଇଁ ସେ
ହଜୁର व्हाटएवर
ଜଷ୍ଟ ରିଭର୍ସ। ଆପଣ ବେଳେବେଳେ ଯାଇକି ରୁହନ୍ତୁ ସେଠି, ଆପଣଙ୍କର ସେଠି ଇନକମ୍ ଅଧିକା, ଖର୍ଚ୍ଚଟା କମ୍। ଏବେ ଟିକେ ଏନର୍ଜି କ୍ରାଇସିସ୍ ହେଇକି ପ୍ରୋବ୍ଲେମ ହଉଛି।
ସମସ୍ତ ଚାକିରି ବି ସେଠି କେତେବେଳେ ଯିବ ସେ ହଉଛି।
ଆଉ ଥରେ ବାହା ହେଇଯାଇଛନ୍ତି?
ନାଇଁ ନାଇଁ ନାଇଁ, ଏବେ 10 ବର୍ଷ ହେଲା ସେ ଏକୁଟିଆ ଅଛି।
ବାହା ହବା ଦରକାର ନାହିଁ, ସେଟା ଗୋଟେ ଜିନିଷ।
ହଜୁର ଯାହା ଯେତେ
5 ଲକ୍ଷ ଟଙ୍କା ଦିଅନ୍ତୁ।
4 ଲକ୍ଷ ହଜୁର ଇନ୍ କେସ୍ ହଜୁର।
ଆଜ୍ଞା, ଆପଣଙ୍କର ତ ଏରିୟର ହେଲାଣି, କରି ଚାଲିବ
ଗୋଟେ ମାସ ଭିତରେ।
ଆପଣ ଟିକେ 5 ଲକ୍ଷକୁ 114 ହେଲେ କେତେ ଟଙ୍କା ଆଉଛି ହେଲେ ଆପଣ? 5 ଲକ୍ଷ ବାଇ 114
4,000
4,000 ଟଙ୍କାରେ ମୁଁ କାହାକୁ ଆଲାଉ କରିନାହିଁ।
4,000 ପାଉଣ୍ଡ।
ହଁ, 4,000 ପାଉଣ୍ଡ ମୁଁ ଏପର୍ଯ୍ୟନ୍ତ କାହାକୁ 4,000 ଟଙ୍କା ଆପଣଙ୍କ ପାଇଁ
ସେ ମାସକୁ
ଆପଣଙ୍କ କରେନ୍ସିରେ 4,000 ଟଙ୍କା ମୁଁ କାହାକୁ ଆପଣଙ୍କୁ ସକାଳେ ଜଣେ କହିଲେ ମୁଁ ଦେବି 1,00,000 ଟଙ୍କା, କଣ 2 ଲକ୍ଷ ଟଙ୍କା ଦେବି, ମନା କରିଦେବି।
ମୁଁ ଆଉ କିଛି କହିବିନି ହଜୁର। ଯାହା
ଆପଣ 4,000 ଟଙ୍କାରେ ଆପଣ ଯଦି ବାର୍ଗେନ୍ କରିବେ କେତେ ହବ?
ନାଇଁ ମୁଁ କରୁନି କିଛି ହଜୁର।
ଆପଣଙ୍କର ସେଠି ବାର୍ଗେନ୍ ହଉନି। ବାର୍ଗେନ୍ ହଉଥିଲେ ସେଠି ଯୋଉମାନେ ଅଛନ୍ତି, ଯାହା କେସ୍ ଚାଲିଛି। କଣ ଦେଖିଲେ? 5 lakhs କେତେ ଦିନରେ ଦେବେ? 5 lakhs that is rupees 114 into 4,000. As he earns in pound sterling, the order dated ଏତେ past by so and so shall not be given effect. ଆପଣ କେବେ ଦେବେ?
ମାନେ 400 ସେ ଆସିବ ତ ମୁଁ ଡକେଇଛି, ସେ ଜୁନ 20 ଭିତରେ ଆସିବେ, ଜୁନ 20 ଭିତରେ।
by depositing the amount by ଭଲ ହେଲା, ଆପଣ ବହୁତ ସେଭ୍ କରିଦେବେ। କଣ 20 ଭିତରେ ଆପଣ ଖୋଲୁଛି କୋର୍ଟ କେବେ?
17 ଖୋଲୁଛି।
17 ପ୍ରାୟ 19 କରିଦିଅନ୍ତୁ। ଆପଣ 20 କହୁଛନ୍ତି?
ହଜୁର ସେ ଆସୁଛନ୍ତି 20 ରେ, ମତେ ଇନଫର୍ମ କର।
22 ରେ ଦେବେ ନା କେବେ?
22
ରେ ଦେବେ।
22 ଜୁନ।
22/6/2026. The learned judge shall not insist for compliance shall not be given effect to the condition. Urgent act copy. Yes.
Hello, please.
Yes, please.
20. Annexure 2 is under challenge, my lord. Annexure 2 page 20.
Yes.
No courtship action ଦରକାର ଅର୍ଡର କଣ ହେଇଛି କି? ଲାବିସି ଅର୍ଡର ହେଇଛି?
ନାଇଁ, ସେଟା ଡିକ୍ଲେୟାର କରିଦେଇଛନ୍ତି ବ୍ୟାଙ୍କ କୁ।
ଆଚ୍ଛା, କଣ ହେଇପାରିବ? ଆପଣ କୋର୍ଟସିପ ଆକ୍ସନ ମିଷ୍ଟର ତ୍ରିପାଠୀ କଣ ନେବେ ଆପଣ?
attach कर दो
Not to act upon annexure
ठीक अच्छी है
annexure 2.
Soumya Kumar Mishra for the petitioner. Mr. Opposite party upon Ajib has the matter is the petitioner challenged by filing the writ application. The petitioner has challenged the so cause notice dated 30/2/26.
No, my lord, that is annexure 2. Declaring garnish.
The order declaring the petitioner as deemed defaulter.
Dated 19/3/2026.
Order dated 19/3/2026, declaring the petitioner banker, banking, banking,
Bank.
petitioner bank, deemed defaulter under section 45 capital G into bracket 3 into bracket X of the ESA Act 1948. Stop. ଆପଣଙ୍କର grounds କ'ଣ?
Ground ଆମେ ସେ ଯୋଉ ଗାର୍ନିସି ଅର୍ଡରଟା ଆ ପୂର୍ବରୁ ଇସ୍ୟୁ କରିଥିଲା ସେଟା ଆମେ ପାଇନୁ।
The petitioner alleges that he has never been noticed in the matters. Is to notice along with this order. Copy of the extra copy of the writ application shall be served on Mr. Amarendra Prasad Ray along with Mr. LD Tripathi.
Yes, ma'am.
Appearing for the opposite
party. Number 1 and
2, the learned counsel, standing counsel, as well as Mr. Tripathi shall obtain instruction and file Kalatnama within 15 working days. Within 15 working days. The opposite party shall have liberty to file counter if so advised. आइए issue notice as above. No coercive action shall be taken against the petitioner bank pursuant to the annexure 2 order dated 19/3/2024 till the next date of hearing.
Opposite part
The matter shall be listed in the week commencing. Listed for admission in the week commencing. 27/7/2024.
another opposite part number 3 is to be noticed.
Principal
employer.
Notice add करो तो notice be issued to OP number 3 by speed post with registration and proof of delivery. Requisites for issuance of notice will be filed within 5 working days.
Mallard's item 21 is covered by Mallard judgment.
21
is covered by Mallard judgment. It is recovery has been done in ASC.
already recovered.
21 you are Mr. Padi. You are Mr.
Mahanti.
Mr. Mahanti, P. Mahanti.
Yes.
This has to बर्तमान से full court आरंभ हो गया है. What's the problem now?
Light dispose of ହେଇ ପାରିବ। 15/5 ରେ ଗୋଟେ ହଜର dispose of କରିଥିଲେ ସେଇ ଲାଇଟ୍ ରେ ଏଟା dispose of ହେଇଛି।
ସେ order ଟା ଅଛି।
ସେ order ଟା ଦଉଛନ୍ତି।
dispose of କରିଦିଅନ୍ତୁ। Madam Jena, your matter during vacation ଆପଣ vacation move କରନ୍ତୁ କାହିଁକି? The problem is now the full court has started.
Item 36.
Speak to 12th of because I
नहीं, I cannot direct.
better maybe
ଆପଣ liberty to mention ସବୁଥିରେ ଅଛି। ଆପଣ release କରିଦେବେ ହେଲା।
additional list TRP ଟା ଖାଲି extension of stay
ସେଟା ହେଇଛି।
ସେଟା ହେଇଛି 23 last item for accession notice
once I leave ମାନେ କରିବା।
36 already there is a settlement.
Plus 25 and 26 is a land acquisition appeal. Identical matters, Lordship has passed order by the same appellant and the same copy I have given.
Item 36
covered matters
25 and 26.
Item 36 mediation report
It is agreed to transfer of the TRPs. Your Lordship.
mediation report shall I submit?
Mediation report is there. Both the parties agreed.
Case number ପକେଇକି ଦେଇଦିଅ।
26 respondent counsel is also consenting.
ସେଟା ବି ଦିଅ।
Yes, please.
This will place ଆଉଥରେ ଡାକିବାକୁ।
Yes, please.